Friends, happy evening to all of you. There was a small technical glitch, hence the delay of this 3 to 4 minutes. Welcome all of you to the day 2 of this IBC preparatory CP meeting. Today we have with us a very good friend of mine, C.B. Ramana Kumar, who is a lawyer as well as a chartered accountant, whose experience spans over 3 decades and has been in practice as CA. Now he's got into the advocacy thing and he knows better sides of both the professions actually. He's a wholesome business advisor with knowledge on accounting, tax and law, including the new generation laws such as IBC and anti-money laundering laws. Apart from advisory, he also defends his clients and pours his advice. Ramana regularly appears for clients before the commissioner level and above in the income tax matters, SESTAT, and other regulatory bodies like SEBI, NCLT, and NCLAT. With the exposure gained, Ramana is a registered insolvency professional and offers consulting as well as acting as a resolution professional. He is one of the most sought out faculty the moment IBC word comes actually. And he has helped many people clear the limited insolvency examination. So you will have to add 100 more people after these classes are over. He's also co-authored a book on transfer pricing with the legendary Sri S. Raghunathan, titled Raghunathan's Transfer Pricing in International and Domestic Transactions. He's also active lion and has won many district governors appreciation award. And very important thing, he's an active photographer and has won many national and international prizes. That's how I know him very closely actually, the photographic interest. He knows the different angles, how the photo can be taken in a better way. And today he will give you the angle in which you can actually do to cover your or clear your IBC examinations. So we welcome you. He's got a huge, big biodata. Maybe for want of time, I will brief it. Ramana Kumar sir, welcome so much. Welcome to you for this day 2 of this IBC program. And I request you to kindly take charge and benefit all the members by your view.
Yeah. Usually the programs of the SIRC are held in the Brahmaya Hall. And whenever I used to come to the stage, I used to have goosebumps because I have sat in the Brahmaya Hall as a student. And now when the institute is recognizing me as a speaker, each and every time I will acknowledge the fact that it is my greatest privilege, pleasure and honor to stand at the Brahmaya Hall to address for anybody for that matter. In fact, the record I had was some 400 or 500 people were there during the budget presentation in 17 or 16. I don't remember. I think Mr. Dugarchan Jain was there at that point in time in the council. We had a huge overflowing thing, which was an overwhelming thing. Now again, in the online mode also, coming back to the institute, it is like actually I'm standing in the Brahmaya Hall on the podium only. I feel. And again, I feel really honored and privileged to be here. And Chairman, as my good friend Mr. Dugarchan Jain said, he is actually known to me as Jain for my children, known as Madurai Jain uncle, and especially my younger daughter is his favorite. So such being the case, being a family friend also, and I actually congratulate Mr. Jain on becoming the chairman. After becoming the chairman, this is the first time I am addressing the institute, and I hope I will do a few more times to come. So that's a great privilege. So with this small anecdote, and I also tell, when Mr. Jain said he is also a chartered accountant. No, I want to be known. Ramana Kumar is also an advocate. I am basically a chartered accountant. From the heart, I'm a chartered accountant. I have incidentally become an advocate. In fact, even during the advocate seminars,
I also say because you are in practice of advocacy.
No, I understand. I'm not blaming the chairman. You are always right. Okay. I'm just making a comment. Yeah.
Ramana, one more thing. During your session, you can give a break at any point you feel somewhere between 5:30 to 6, a time of your choice, for 5 minutes so that people can take a comfort break.
Yeah. I will do.
Yes, sir.
Okay, sir. So I think with this we'll go. In fact, I should place on record that it is the CA Institute platform which made me an instructor, which made me a teacher and which made me a mentor in IBC. And I was one of the initial faculties of IBC in India itself, wherein the whole gratitude and the whole credit of this goes to the past senior Central Council member, Ms. Kumar, who was actually instrumental in requesting me to make the first ever presentation on IBC in the CA Institute, which happened again in the Brahmaya Hall sometime in early November of 1960. Of 2016. Immediately after the code became the act, immediately after the bill became the act. So I was privileged to address the crowd, address the members and others on this matter. And we have made, and for all the classes, just to inform as I go into the presentation, is that I have taken classes on IBC for almost all the branches in the South India and a few branches in the North as well. And I will just explain the way in which the class will be held. I would like to call it a class rather than a session, because I would like to only concentrate from the exam point of view. Please understand, the first requirement for each one of us is to clear the examination. There might be some logical questions, there might be some factual questions. All those things are appreciated, all those things are accepted, but our concentration will be is to clear the exam. And now we are going to go into the part 3 of the code. I guess all of you have the code in front of you. It is very important that you have the code in front of you so that we can make some notes. And in the process, I will also be sharing some examination questions. So please be careful. Please be attentive is what I would require. And all of us have studied well, and only then we have all become chartered accountants or any other profession in which we are now. Again, we need to go back to our student days. In order to clear the IBC exam, I would honestly require all of us to go back to the student days, concentrate like a student and study. Only then this exam can be cracked. In fact, as I told you, the reason why I told you that I'm a faculty from early November 2016 is the fact that I wrote my exam in June 2017, thinking that I am a faculty. I have already taught for so many people, and we have then, I can crack the exam like this. So I wrote the exam in June 2017 after having experience of around, say, 40 to 50 hours of taking classes itself, leave alone studying, of taking classes itself, but I miserably failed with 48 marks. Then again I wrote in September with some improved confidence, but some lower or more confidence, I would say. I got only 59 marks. And then I really sat down for 1 month. I studied like a board exam student, like a student who studies for the final exam of chart accountancy, morning 4 to 8, evening 7 to 11, continuously for about 25 to 30 days. And I was able to clear the exam with 68%, which is a very good percentage, I should say, at that point in time. Only after the third attempt, I realized, I appreciated, and I was aware of the fact that how one has to study for the exam, and where one goes wrong, and what one must do to unlearn and then relearn. There are a few things which we have learned. It has to be unlearned by us, and the new concept has to be relearned in order to clear the exam. So my presentation here, or my class here, is only O with the capital O, for clearing the exams. I think, in fact, my presentation itself says limited insolvency examination only. It is not a class on the concepts or on the subjects, only to clear the exams. So what I will do here is, I'm so sorry. I had I was in another session between 1 o'clock and 4 o'clock with the income tax department. So my sore got a bit, my throat got a bit sore, and I requested some hot water and coffee. I am sorry about this. So you will see that the presentation itself is called limited insolvency examination only. It is not a treatise, or it is not an essay on the individuals and partnership. It is only for the examination. Again and again, I am reiterating. In the process, what I will do is I will share some examination questions, how to remember those examination questions, compare the individual and partnership with the CIRP which you studied yesterday, and try to make a difference between them, identify a question which is actually from CIRP, or identify the question that it is from individuals and partnership, is what we have to see. So now today we will be dealing with section 79 to 120. 79 to 120 is the session we will be dealing with. It will be in 3 presentations. The 3 presentations are, one is the preliminary one, the other one is the fresh start, third is the insolvency process for individuals and partnership. So these are the 3 ways in which we will be presenting the whole section, and it is exactly as per the code only. It is there is no change with respect to how it is from the code. It is from the code. So I expect all of you to have the code with you, at least the printouts of section 78 to 120. If you don't have, you can immediately instruct your office to take the printout, or if it is possible for you to parallelly take the printout, please take the printout, because I will be requesting you to underline certain important words, phrases, etc., which will be extremely essential and crucial during the examination, a day before the examination. My endeavor would be is to, if you are able to attend this class with full earnest, you in all probability need not revisit the textbook or the code again with respect to individuals and partnership. It will be literally a hand-holding master class on individuals and partnership, which I will be taking, by which you will be able to appreciate all the nuances, compare it with the CIRP process, and also try to understand the various questions which will emanate from this process, which will be useful for us. So we are going into the insolvency and bankruptcy code, and we are going into part 3. It is known as part 3. Part 1 is definition, part 2 is CIRP, part 3 is insolvency bankruptcy code. Examination question. Examination question will be the bankruptcy relating to individuals and partnership firm is found in A, B, C, D, part 1, part 2, part 3, none of the above. So part 3 is 1. Immediately you will get 1 mark. Please be careful about it. Otherwise, minus 0.25. So part 3 is the insolvency bankruptcy for individuals and partnership. If it was a physical class, I would have made the people repeat it after me. Please don't mind. I am treating you as students. I am treating you as children. The ego of a chartered accountant is shattered here. Please bear with me for this 3 hours or 3.5 hours. Please listen to me and please submit yourself to me, in the sense that you will not be required to revisit this portion again. Please remember, 78 to 120 is a hell of a lot of section to study during the examinations, and all you need to do is only check my presentations which I have, and you are through in the examination with respect to this chapter. So this being the case, please understand part 3. Okay. Now we will go into for whom and all it is applicable. The section 78 and 79 which we have seen, section 78 and 79 is only the definition section. Sections, I'm sorry, section 78 reads, this part shall apply to matters relating to fresh start, insolvency, bankruptcy of individuals and partnership, where the amount of default is not less than. Somebody can unmute yourself and also answer if you want to really take part in all this. In case you want to use the chat box also, you can use the chat box liberally and you can just answer. I will also have the look at the chat box, no problem. And not less than rupees 1,000. For CIRP, this threshold limit is 1 lakh. Please understand, for you, June 2019 is what is relevant. March 2020 is not relevant for you. Please try to understand. At this point in time to write your insolvency exam, June 19 is essential. June 19th, the CIRP threshold is 1 lakh. The individuals and partnership is 1,000 rupees. Provided that the central government may by notification specify the minimum amount of default of a higher value, not more than 1 lakh of rupees. So the question will be the highest amount, the maximum amount for a CIRP and a PARP is, the correct answer would be for a CIRP it is 1 crore. It has been made now. 1 crore is the maximum amount. And for a PARP, the PRP we will take it as the personal insolvency resolution process. Okay. So for a PARP, the maximum threshold is only 1 lakh. So for a CIRP situation, it is 1 lakh to 1 crore. For a PARP situation, it is 1,000 to 1 lakh. Please understand that. Please underline section 78, not more than 1 lakh of rupees, or note it down somewhere. And it is for whom? It is for individuals and the partnerships. Partnership includes the partners? Yes. Individuals, it is for the individuals. For what? For the insolvency and the bankruptcy process of these two entities. What is the minimum threshold? 1,000 to 1 lakh. Okay. Now we will go into the key definitions. I am only going into the most important definitions as of now. The other definitions are also dealt in the other slides, but here the most important definitions are addressed here. One is associate. Associate is subsection 2 of section 79. Please make a note. You have that. Who is an associate? We'll have to see. And the other thing is the bankruptcy trustee or the bankruptcy. What is the meaning of bankruptcy? These we need to see. And the third important thing is the excluded assets and debts. Excluded assets are different, excluded debts are different. Being chart accountants, invariably you will understand that the assets include debts, but for the purpose of the IBC code, there is a different definition for excluded assets and there is a different definition for excluded debts. And fourth most important thing is the qualifying debt, which are the debts which will be qualified. Now we come to the associate. If you see the definition, you will have A, B, C, D, E, F, G. 1, 2, 3, 4, 5, 6, and 7 thing we will have. For us to easily remember the associates, I have just highlighted the important phrases. First is whatever is applicable to you is applicable to the spouse. Whatever is applicable to an associate is applicable to the spouse of the associate. Please remember that. So, who is the associate of the debtor? The associate, it is resounding. What do you mean by resounding, Srinivas? Selva, are you there?
No, I think it's talking about the echo. I think it is okay only, sir. Maybe some problem with their device.
Is there a problem with everybody? Are you getting the giant?
Yeah,
No,
your voice is pretty comfortable, sir, for me.
Okay, fine.
If they're using headphone, they can use a level below 30 or 50, so it will be fine.
Yes. You are MP Srinivas from Bangalore, no? We were roommates somewhere, no? MP Srinivas? No, I don't know. Okay, fine. So, a person belonging to the immediate family of the debtor. Who is the immediate family? Husband, wife, children, father, mother. Father-in-law, mother-in-law, immediate family? No. Father, mother, immediate family? Yes. Typical situation of a middle class family you take. Immediate family means the husband, wife, children. How much ever children? And the father, mother. Next concept is a person who is a relative of the debtor or the relative of the spouse of the debtor. So, if you see the relative of the debtor, make a mirror image, it becomes a relative of the spouse of the debtor. Who are the relatives of the debtor? Father-in-law, mother-in-law. Because we left them in the first one, no? And to be politically right, you better include the father-in-law and mother-in-law of the person who is a male. I'm just taking, for example, a male father-in-law, mother-in-law. Relative of the debtor, ascendant relative, uncles. In Tamil, we call Chitapa. And the mother's side is equivalent as Mama. So, the uncles, aunts. So, uncles include the aunts. And similarly, your cousins in your generation, your cousins, your uncles' children, your aunt's children, coming down, your children and the relatives of your children will all come under the question of relative. The reason why I am explaining so much is that in a case study for 6 marks, this one relative will come and close the matter. So please try to understand that. Similarly, a relative of the spouse, wife's uncle, aunts is a relative. Of course, wife's children are your children, obviously, unless there is a problem in the family, it will be the same. And the linear ascendant also will be the same. So, the linear descendant will be the same. The linear ascendant, the uncle, aunts of your wife will also be the uncle, will also be a relative under section 79(2). And the cousins of your wife will also be the relatives, especially the brothers, the sisters of your spouse will also be a relative. Please try to understand, wherever you can influence your ideas with a family member, they invariably will be covered in the relative list. Now we come to the partnership. All the partners of the debtor, here the debtor, as we saw yesterday, corporate debtor was the company, this individual is a debtor. Individual is a debtor. So it is for individual and partnership. So in this case, what happens is any person who is in partnership with the debtor will be an associate of the debtor. So again, try to extend what we have seen in the first two meanings. The spouse of the relative, spouse or relative of any person, spouse or a relative of any person who is whom the debtor is in partnership. So the spouse and the relative, the same relatives, you are mirrored to the spouse, and the same relatives are mirrored to the partners, each one of the partners of the partnership firm and the relatives. So your partner's uncle will be an associate of you. Please remember, partner's cousin will be your associate. Your partner's wife's cousin will be your associate. Your partner's wife's aunt will be your associate. Your partner's children will be your associate. So the meaning of associates is very far and wide. It will also include all these things which we are seeing now. Now this is up to the individual level. You have this. Or am I clear in this? Any clarification you have? If you have any clarification, please let me know. Not in Income Tax Act. Under the Income Tax Act, is it identical? You have to check it, because according to me, the definition of an associate in IBC is much wider and larger than the definition under section 79 of the Income Tax Act. So we will also have a look at 79. I also have 79 with me. Excellent, Mr. Mandakini. Mandakini madam, you have made a very good point. We will also check 79. What is the problem? We have all the time in the world. I have been instructed by Revathi madam that I can go until 9 o'clock in the evening. So absolutely no problem for me. We will do all the research and do. Madam, section 79. Yeah, section 79 in IBC. Okay. I got.
Ramana sir,
We are dealing with section 79 only, madam. We are dealing with section 79. Divorced spouse. Would you be able to influence your divorced spouse? I don't think so.
Ramana sir, only one correction. Don't go till 9 p.m. It is only till 8 p.m.
I know, sir. I know that, sir. I know. I wanted somebody to react. Nobody is reacting. That is right.
You are going to make people run away.
I know. You also have to go to Madurai. I know that. Okay. So the first four is with respect to individuals and the relationship of individuals with each other. Please try to understand. The first four is with individuals and the relationship extent. If you can just do a tree map and understand, you will immediately understand the whole thing. And now we come to the next person whom you can influence. Whom you can influence? You can either influence your employer or your employee. So, influencing an employee is the easiest thing to do, isn't it not? Influencing an employee is the easiest thing to do, because you offer him an incentive, immediately he will do whatever you want. That is why in the Binami Act and Female Act, if you see, all the drivers, the gardeners of all those people are all holding huge amounts of wealth for the simple reason they are being influenced by the respective employer. There are situations where you can influence the employer also. I don't know how, but you can influence. So a person who is an employer of the debtor or the employee of a debtor is also an associate person. Maybe the intention of the legislation to include the employer was, it can be structured in such a way that you can be structured in such a way, the whole process, the PRP can be structured by the employer to the employee by trying to siphon off some money here and there. Something can happen. So let us not go into it. Please include the employer and also employee. Our intelligence, CA intelligence will come in between when we are writing the exam. When we are writing the exam, we will see that the employer can influence the employer. Employer is also an associate of the employee. Immediately, our intelligence will come in between and say, no, how can an employer influence an employee, man? It is what it is. I mean, how can an employee influence an employer? No, it is wrong. It is only the employee. Please tick it wrong because the various option you get for this thing also will be varied. So you will be drawn to a conclusion, trapped in a conclusion to say that you will say employer is not an associate. Please make a note, please underline, please highlight to say that employer is also an associate of the debtor. Next is the trustee. Trustee invariably a trustee of a private trust. It says very clearly says for the benefit of the debtor. Where it says for the benefit of the debtor, please understand that we are only talking about a private trust. One question which comes. The question will say of a charitable trust in which you are a beneficiary. You can be a beneficiary in a charitable trust. But if you are a beneficiary in a private trust, that trustee also happens to be the associate of the debtor. Please understand. So we will read this. A person who is a trustee of a trust in which the beneficiaries of the trust include a debtor or the terms of a trust confer a power on the trustee which may be exercised for the benefit of debtor. Even a power on the trustee is constituted as an associate of the debtor. So one needs to be careful. You can read it in whatever way you want. You only have to say from the trust, if you receive a benefit, that trustee is your associate. You don't have to apply any other rules here. From the trust, if you are able to read that it is from a trust you are able to take the benefit. From the trustee has the power to grant you the benefit. Maybe the trustee is authorized signatory or maybe he has the power to release the money in whatever way it is. That trustee is also an associate. A company where the debtor along with his associates means, please understand, along with his associates means all the people up. Everybody included from A, B, C, D, E, F. All the people from 1 to F own more than 50%. So a case study will come. A company in which the shareholders are the spouse of the partner of the debtor along with the cousin sister of the partner of the spouse of the debtor. As and when the relationship becomes longer, we will be tempted to say no. Hold around 51%. Again, the thing will be that again the 50% is extremely important. 49.9, no problem. 50 and above, problem. Or controls the appointment of the board of directors. There can be a situation, a question which says that these persons are not the shareholders but have a say in the board meeting because they are consultants, HR consultants, YR consultants, whatever it is. So, associate of a director, you must not read this again. I should say that you must not read it again. You must understand it straight from the slide here. Immediate family, relative, spouse is immediately parallel. So, immediate family, relative, partner, partners, relative, employer, employee. So in the first four, immediately it will mirror the spouse also. And again, the trustee who is in the benefit of the trust and any company where 50% is the key and it must have any of the associates which are listed above. So this is called an associate of a debtor. We have completed only one definition in section 79. And now we go to the next one. Bankrupt. Again, in bankrupt, there are three subsections, debtor who is adjudged at the bankrupt, and bankruptcy order under section 126. Please note it down. Bankruptcy order under section 126. Bankruptcy order is akin to a what you call a liquidation order under 126 section is very important. Each of the partner of the firm where the bankruptcy order under section 20 is against a firm. So where a firm becomes bankrupt, it is understood that each of the partner will also become will be dragged by the firm into the bankruptcy. They will also be bankrupt. So a bankrupt is a partner of a firm which has been made bankrupt under 126. Any person adjudged as an undischarged insolvent. Undischarged insolvent, we can see insolvent is a person who has become, who is not yet discharged by way of subsection 13, which is a discharge order. By way of that, it has not happened. So he is an undischarged insolvent. So bankrupt is a person who has been adjudged as bankrupt under 126. Please remember section 126. Bankrupt means 126. Bankrupt is subsection 3. 1236 is what I will remember it as. 1236 means bankruptcy. Bankrupt. Section 126 is the order which we will see a bit later. I think it's beyond the scope of today's class. We are only dealing with 119. 126 will be, I think, taken in the last class by Aneetha madam, who is another excellent teacher and who has been my teacher also to complete my last exam, where she structured the whole study in such a way that we were able to study in a structured manner to clear the exams. Again, who is a bankruptcy trustee and insolvency professional appointed as a trustee for the estate of bankrupt. Again a question, again an examination question. In all permutation combination it will come. The important thing is only an insolvency professional can be appointed. He is only appointed, he is not elected. He is only appointed, or he is not directed by NCLT. He is appointed or chosen. Elected is all wrong. Appointed as a trustee, as a what? As a, not as a COC member, not as a member, not as a participant, as a trustee for the what of the bankrupt? Estate of the bankrupt. The other options will be liquidation assets of the bankrupt. The insolvent bankruptcy trustee means an insolvency professional appointed as a trustee for the participation of the bankrupt, or it will be a banker appointed as a trustee for estate of the bankrupt. Immediately what we will see, we know the merchant banker, immediately our professional mind will come in between. It will forget insolvency professional. It will say a banker, means we will tend to accept it. So in an examination where the various options are given in various ways, please understand the bankruptcy trustee, always the trustee is insolvent. Liquidator is an IP. Insolvency trustee is an IP. Resolution professional RP is an IP. There cannot be a situation where any other person can be appointed as a trustee of a bankruptcy trust. Only the insolvency professional can be appointed. Please understand one more thing, when the appointment of resolution professional in CIRP, you would have studied from an IRP to RP, it is not automatic. IRP to RP is not automatic. IRP, in the first COC, you have to elect the RP. Even if you are continuing the IRP as RP, you must pass a resolution stating that the COC approved the appointment of the interim resolution professional as the resolution professional. So IRP to RP is not automatic, whereas RP to liquidator is automatic. The RP is the first liquidator of the company. Unless the RP says he doesn't want it, or there is a case pending against him, or there is any other reason by which he is not appointed, by default, it is the RP who becomes the liquidator of the companies. So the long and short of it is in CIRP, not in the individual bankruptcy. In the corporate bankruptcy, IRP to RP is automatic. It's not automatic. RP to liquidator is automatic. So please write IRP. Please write. Can I share? Can I share? Empty screen. Okay. I will just write it here. IRP to RP, not automatic. From RP to liquidator, here it is automatic, not automatic. And here it is auto. Okay, please understand. It's an important question which comes in IBC exams. Easily you can get 1 mark. From this thing not automatic, this is automatic. Okay. Now we go to the next thing called as the discharge order. Discharge order is subsection 13. Again, you have to remember the three section numbers 92, 119, 138. Even in the sleep, you must be able to recollect because they will change the order and ask one question. It was an examination question. 93, 118, 137 will be one option. 92, 119, 138 will be one option. 92, 93, 119, 138 will be option. So you need to remember all the three. 92, 119, 138. It's a very, very easy thing to remember. Please write it somewhere and keep remembering it once in a while. The discharge order is an order passed discharging the debtor under the sections 92, 119 or 138 as the case may be. This is very important. Sorry, somebody has written something here. Sir, RP will be removed by AA once the resolution plan is submitted in not accordance with. No. Yes. In case there is some problem with the RP, he will not become the liquidator. Please understand. Where there is a problem with the RP, where there is a disciplinary proceeding against the RP, where the RP has not checked the resolution plan, all those things are exceptions, my friend. The only situation where it will happen is if the RP is able to do everything in a correct way. No, it is automatic. Please don't confuse yourself. It is automatic in the sense that I am not looking at exceptions. I am only looking in the normal circumstance. In the normal circumstance, it is automatic. In the normal circumstance, it is automatic. In the normal circumstance, from IRP to RP is not automatic. Am I audible? I have something rounding here.
Sir, you are Ramana sir, you are audible, but we have lost your video actually. That's
lost the video. No, okay. If the video is lost, no problem.
Yeah, your audio is very much intact. You can continue, sir.
Okay, very good. Excellent. Sir, please don't confuse yourself. IRP to RP under normal circumstance also is not automatic. You have to pass a resolution. But for an RP to liquidator is automatic under normal circumstances. You are citing situations where there are exception circumstances wherein the RP has not fulfilled the conditions placed by the code. Okay, please try to understand that. my God.
Ramana sir, you are there?
Yeah, I'm there. I'm having some bandwidth problems. My screen has gone completely, so I'm not able to see the presentation.
Okay. We'll wait.
So now we'll come into the excluded debts. So I'm just seeing from the code which I have. It's raining here, Duga. So because of this, I think there's some bandwidth problems. Okay, now we'll come to the excluded debts. Excluded debts, you don't have an option. You will have to understand it the way you can understand it right now in a sequential format and understand it. The excluded debts, the debts will not form part of the bankruptcy estate or bankruptcy estate or the assets which the debtor can actually enjoy with himself. These are the excluded debts. Excluded debts are unencumbered tools, some plant and machinery, etc., which is not encumbered. For example, a laptop in which there is no loan outstanding is an unencumbered tool. Books, vehicles, and other equipments as necessary to the debtor or the bankrupt for his personal use or for the purpose of his employment, business, and vocation. According to that, if you have 5 vehicles, you have 5 vehicles ranging from an old Alto to a new Mercedes-Benz. Whether you can retain the Mercedes-Benz or whether the bankruptcy trustee will allow you only to have your old Alto is the issue to be seen. We will see that later. Unencumbered furniture, household equipments, etc. for his immediate family. First for himself, for his employment, for his vocation. Next comes some assets for his family. Third is unencumbered personal ornaments of such value as may be prescribed, the jewels of the spouse or for the family or for the individual also, which cannot be parted with in accordance with religious usage. Please understand.
Ramana sir, we have lost the PPT also. If you can just put it again.
PPT I am able to see, but I have
it is not appearing on the screen. We are not able to see.
No problem. But you have the people have section 79 subsection 14. Please look up 79 subsection 14. I think all of you must be having the code with you, at least in your computers, which has been shared by the institute.
No, it is there, sir. But
sorry,
are you not able to share your PPT, sir? Is there any problem with that?
No, I don't have any problem, but I think the bandwidth is very bad here.
Video only will get cut, sir, but PPT you can share, sir. It will not be a problem.
PPT I can share, no problem. It has already been shared, no?
No. You share it on the screen, I'm asking, sir.
No, it is there on my screen only, Baba. It is there on my screen only.
No, sir, it has got disconnected. You share the content again.
Also, you need to rejoin. So its name is not on the panel list. So we need to.
1 second, sir. 1 second.
So what I'll do is I will log out and come out again.
No, sir. Don't do, sir. Not required, sir. Not required. 1 second, sir. Just 1 second. Selva will make you presenter so that you'll be able to share the screen, sir.
Yes, I am already a presenter. I need to 1 minute. I just open the. I'll share a screen, no problem. I want to know which PPTs are there. Is 3 PPTs shared by
0, 1. The first PPT is 0.
Okay, sir. Okay, sir.
As,
on which page, sir?
Slide number 10.
10, okay.
Yeah,
what is excluded on? Okay, I'll share it now.
So, Ramana sir, you can with Selva, he will take the slide so that it is easy for people to recorrect.
Yeah. No.
Yes, sir.
My image is frozen. My everything is gone. I'll have to reconnect again, I guess.
Sir, then I think it's better if you reconnect, sir. Then in that case.
Yeah, I'll do that.
Yeah, I think it'll be better.
Yeah, I'll do that.
Yeah. Meantime, I'll use the time to make the announcements of the forthcoming program.
Yes. You can, sir. You can.
Yeah. One second, let me pull the programs. On 1st, 2nd, and 4th of August, we are having a tax audit refresher course, a 3-day course, where Dr. Vinod K. Singhania, K. Guraj Acharya, and Pramod Jain are speaking on the perspectives of tax audit. And on 6th and 7th of August, Thursday, Friday, we are having 2-day refresher course on tax audit and technology. Then on 8th of August, we are having statutory audit 2019-20 with a demonstration of detailed audit checklist by CA K. Shripriya. And on 10th and 11th of August, we are having a 2-day program on GST audit. The details will be updated shortly. And on 22nd of August, we have a program by CA Kapil Goyal on how to draft, reverts to the notices which we receive from the Income Tax Department. So these are the 5-6 programs which are lined up for this month. There are a few more which are just, near the final stage. As soon as that is finalized, we will be putting it on the website, and also will be making the announcements duly. We'll wait for Ramana Kumar sir to join again. Tax audit, it is on 1st, 2nd, and 4th. It is a Saturday, Sunday, and Tuesday. In fact, we wanted to have it on Monday, but one of the speakers said that first day of the week it will be difficult for people to, come and attend the program. So we have made it 1st August, 2nd August, and 4th August for the benefit of everybody. And for the study materials, few people are still asking. We have already shared it in the chat box. I'll do it again. And this link is going to be the same for all the days. We will keep updating it as soon as the speakers give the presentations. I'm sharing it again for the benefit of everybody. You can copy it and keep it as a record for all the days. And do spare a moment to give your feedback also once the program is over. Selva, can you just talk to Ramana Kumar sir and check whether he's having any difficulties? Can you share the video as well? Yes, after all the program, the 5 days are over, we'll be sharing you all the recordings as well as the resources through a separate email actually. We'll be doing that, don't worry.
Sorry, sir. Technology is playing havoc.
Yeah. Technology.
That's why it's at 9 o'clock now.
So technology fails it when you need the most, but still we have to live with it.
Yes, we have to live with it. We don't have an option. We don't have an option. 1 second, sir. I'll just connect my presentation.
Yeah. For the 44 ABCP program timings, it is in the morning. First day it is 11 to 1. Other day it is 10 to 1 p.m. It is in the mornings. The first half of the morning before noon. Ramana sir, wait sir, I think we'll have to give you the rights of the presenter. Wait sir.
Yeah, you have to.
It's given, sir. It's given.
It's given. Okay. Yes, sir. It is slowly coming.
Yes, coming.
It has come, sir, already.
At last. Yeah, very good. So, again, I want to reiterate to a friend of mine who said that it is not automatic. Generally, IRP to RP is not automatic. Generally, RP to liquidator is automatic. Only otherwise, if there are some exceptions will happen. Please don't confuse yourself on the exceptions. Taking the exceptions to say that IRP to RP is, from RP to liquidator is not automatic. Only on exceptions it is not automatic. Generally, it is on automatic. Okay. So now we have come to the very important thing of the excluded assets we have seen. As the important assets of the debtor. If you may remember in the film Shivaji, all the assets of Shivaji will be taken off. Suddenly the bank manager will say, sir, you have to give the Rolex watch also. In fact, the first show, the theater was almost broken because of that statement. So he has to give the Rolex watch also to him. But in case of bankruptcy, where it is required for the purpose of his employment business vocation, you can have it. Unencumbered, next, first is the personal one, next is the family, and third is the gold ornaments as per religious usage. Third, gold ornaments as per religious usage invariably amounts to the Mangal Sutra of the Hindu women, or where the respective religions are there, the respective identities of marriage. For a Christian couple, both the rings might be excluded, something like that. But you cannot say a man's Pulinagam chain is an unencumbered personal ornament. No, it is not. It is not an excluded asset. It will be included in the estate, bankruptcy estate of the person, which will be liquidated and all the creditors will be settled. Only the assets which will not be taken for the purpose of settling the creditors are the excluded assets which we have seen. Any unencumbered life insurance policy or pension taken in the name of his immediate family. Always life insurance policies have a unique advantage over others. There is a marriage women act also which is there, out of which the assets which have gone through the marriage women act also cannot be touched. An unencumbered single dwelling unit owned by the debtor of such value. If I have only one penthouse, if I have only one house, I have only one dwelling unit of say 5,000 square feet. That one dwelling unit is the only dwelling unit I have, and there is no encumbrance on that. I have settled all the loans. There is no housing loan. That is an excluded asset. Please understand. Personal ornaments of male debtor, even if it is unencumbered. I'm sorry, I wasn't able to see the. 1 second, I will just open the chat. The personal ornaments of male debtor, even if it is included, are not excluded. Exactly, according to me, yes. For a male person where there is no religious, for a Christian male, the wedding ring is in accordance with the religious usage, isn't it not? And unencumbered, it is not saying unencumbered personal ornament of women alone. No. What value prescribed? The value will be prescribed when these rules are notified. Now it is not notified. Now the whole part 3 is not notified. Of such value as may be prescribed. They will not ask you whether it is 1 sovereign, 2 sovereign, 5 sovereign. No. It will not be asked. It will only be as may be prescribed. Unencumbered life insurance policy and unencumbered single unit. Okay. Now we come to the excluded debts. Earlier we saw the excluded assets. Now we'll come to the excluded debts, which is 79 subsection 15. Any fine imposed by a court or tribunal, liability to discharge, paid, damage for negligence, nuisance, breach of statutory, contractual, other obligation. In one class, one person asked me, sir, I am in a moratorium. In a CIRP situation, I am in a moratorium. I am crossing the red light. The policeman is fining me, say 1,000 rupees. Can I say that I have in moratorium, you cannot do anything to me? No. It is not applicable in that situation. Where is the limit excluded described in notification, sir? What is that? Where is the limit excluded that prescribed in notification? Section 79 within brackets 15, madam. Is there any value prescribed in case of dwelling unit? No. It only says one dwelling unit, one unencumbered dwelling unit. If it is encumbrance, your person who has the secured mortgage will take the asset from you. No, I'm not able to understand the question of Ms. Mandakini Siddhartha. If you can just explain it, I will try to answer it. So these are the excluded assets which we have. And next we come to the excluded debt is any fine or tribunal. Wherever there is a fine because of non-compliance, wherever there is a fine because of any negligence, wherever there is a fine because of an error attributed or attributable to the debtor, those are all excluded debts. Apart from two things is the student loan. Liability in relation to student loan is not accepted as a debt which the estate will pay for the simple reason, a commonsensical reason, is that a student loan must be repaid by the student after he graduates. Even though that loan is taken by the debtor, even though the loan is obtained by the individual, even though the whole loan is being taken by the debtor for the purpose of his son, it has to be repaid by the individual only. So that is the reason why a student loan is excluded. And all other debts as may be prescribed, which is not prescribed as of now, which may be prescribed as and when it comes into play. Now we have to go to qualifying debt. Qualifying debt is which subsection? I want to know if you people are really having the code in front of you. Which subsection is qualifying debt? Please bear with me. I've been shouting from 1 o'clock, so occasional sips of hot water will make my throat go sore. So excuse me on that. Okay. Qualifying debt is 79 subsection 19. Yes, very good. Thanks a lot. Thanks a lot, Sujaji. Thanks a lot, Deepak. Thanks a lot, Ganapati. Thanks a lot, Mandakini. Yes. The reason why I'm asking you is, please bear with me. You have to be my students for the next couple of hours. Only then, see, we have only covered about 5 subsections as of now. This is the way we need to read the whole act in order to crack this exam. Okay. Now we'll go into the qualifying debts. Qualifying debts includes interest and other sums due to in respect of the amount owed under any contract. What are the examples of the other sums? The examples of the other sums may be any liquidated damages which is agreed, escalation fines, etc., by the debtor for a liquidated sum. And the qualifying debt would be either immediately or a certain future time. All these things have actually emanated, have become liabilities or will become a liability within a short span of time before the whole exercise is being done. And what are the exclusion? Obviously, the excluded debt which we saw in the last one, all these excluded debts. Apart from that, it is also a debt to the extent in which it is secured, because all secured debts will be taken, all the security will be taken by the respective lenders. So there is no situation, that there is no point in you trying to include the secured debts in also a qualifying debt. And would there be a situation where the bank will say, no, I don't want to take possession of the house. You can include it in the qualifying debt. No, there will not be a situation at all. Or if an NBSC has given the car loan, they would want to take the car rather than try a situation in which they enter into a qualifying debts by relinquishing their rights, which in a CIRP process it is possible. Any debts which is incurred 3 months prior to the date of the application of the fresh start process. Not possible, because I will say that I will take the loan only with an intention of entering into a fresh start process or entering into a personal insolvency resolution process, PRP. So I don't want all that to happen. So to be on the safer side, any loan taken 3 months prior to the start of the fresh start process is not an qualifying debt. Why is it not included in the excluded debt? It can be included as part of the excluded debt also. The reason why it is not included, it comes in any other debts as may be prescribed. It is coming in any other debt as may be prescribed. It is a debt which is incurred 3 months prior to the date. Please understand, again a question, an examination question. Excluded debt includes any debt which has been included 3 months prior to the date of application of the fresh start process. You have to say yes or no. Next one is the repayment plan. Repayment plan is a plan prepared by the debtor. Again, examination question. Please note it very carefully. Repayment plan is prepared by the debtor. Resolution plan is prepared by the resolution applicant in CIRP. In a individual partnership, the prepayment plan is prepared. Only you will know you are wherewithal to repay the money. Nobody else will know. Similarly, in a resolution applicant, only the resolution applicant will understand, will know how much he can pay, how much he can take the money, how much he can, what all he can make the payment. In consultation with the resolution professional, the repayment plan is made with the resolution professional on hand. In the next presentation, you will appreciate that it is literally the insolvency professional or the resolution professional who leads the debtor, literally by catching his hand, like you leave a child to the school. Like we leave an LKG student to the school, the resolution professional will be mentoring the debtor in every step in an individual resolution. But in case of a CIRP, it is not in consultation with the, it is not in consultation, it is only with the review made by the insolvency professional. It is an insolvency plan is a plan prepared by the resolution applicant and placed to the COC by the insolvency professional. He has no role in that at all. Please understand, but in an individual partnership, the resolution professional has got all the role. It is he, under his consultation, under his mentorship, under his advice only, the repayment plan is prepared by the debtor under section 105, containing a proposal to the committee of creditors for restructuring his debts or affairs. Okay. Affair means only financial affairs. Immediately there was a question in one place where, sir, all kinds of affairs will be adjusted. Yes, sir. No, please, I'm not joking. It was a very serious question asked by a very serious person. Only financial affairs. All the IBC matters are only with relation to the finance. Moratorium is only with relation to the finance. Assuming that we have a moratorium, if the debtors indulges in smuggling, in some antisocial activities, etc., the respective laws will take its course. You cannot say, I am in a moratorium, you cannot do anything. It is not a free for all. Please understand that. Okay, any questions up till now? Otherwise, we can go to the next session now. If you have any clarification, you can just unmute and ask me. Okay, I presume that there are no clarifications. I will go into the second one. Is the fresh start process, IBC codes, SIRC. I will go. Oh, I'm sorry. Stop sharing.
Yeah, Ramana, so the screen got shared and closed again.
Yeah. No. I'm just trying to get my
file
so that I can just open it. I have closed that one second. Okay. And why am I not able to share that? Page. Sir, is the speed okay? Is it okay, or you want me to either increase the speed or reduce the speed? What do you feel, sir? You can ask the.
Yeah, participants can write in the chat box.
Participant can write in the chat box.
Yeah. So there is little silence, which means the speed is okay.
Okay, now we come to the main play. Up till now, you have been seeing only the news reel. Now we'll come to the main picture. The Shivaji picture will start now. Okay, so if we see, I will go into the fresh start process. Fresh start process is from section 80 to 93. Please understand that there are two kinds of process. Fresh start process is a process only in individual and bank, individual and what we call partnership. You can speed up the presentation. Okay, one person says I can speed up. One person says okay, fine, increase, decrease. Okay, fine. So I will try to do it accordingly. Fine. Now we go into section 80. Section 80 is eligibility for making an application. Who can make the application? Next we come 81 is the application for the fresh start process. And then appointment of the resolution professional is 82, and the impact of the discharge order. These are the main main areas which we will see for between 80 and 93. Okay, so here first is, this is the broad flow. Please note it down if it is possible for you, so that only if you write it and see, you will be able to appreciate. So the broad process flow, we will go, each one of it is one section, or one section may be broken into two. So we will just see. First, the application is to be filed. Immediately, the interim moratorium commences for individual partnership. Please understand, for a CIRP process, it is not so. Only when the question is admitted, only when the admission is made by the AA, is the moratorium starts. Here, for individuals and partnership, immediately on filing the application, the interim moratorium starts. All you need to have is an acknowledgement for filing the application. Your moratorium will start. After that is the appointment of resolution professional. The application, in the application itself, you need to appoint a resolution professional. Here, the resolution professional in the CIRP process is made only after the admission order, but before that it does not happen. So appointment of the resolution professional given a copy of the application. The application which has been filed by the debtor is given to the resolution. So which means the resolution professional has got no role to play in filing the application. Earlier we saw in the definition that only in consultation with the resolution professional, he will only do the resolution plan, and filing the application, there is no involvement of the resolution professional at all. But in reality, if you see, always it is the resolution professional who will actually advise or enter the whole thing to be done up and to do it. RP will review the application and recommend the acceptance or rejection. It's a new process. So you see, the RP is all powerful here. It is the RP who will actually dictate all the terms. Here, it is the RP who has to see whether the thing can be accepted or rejected. And RP presents a report to the adjudicating authority. Who is the adjudicating authority here? Please. It is the adjudicating authority will be presented with the report and the admission will happen. Yes, the adjudicating authority is DRT, Debt Recovery Tribunal, and the appellate authority is the DRAT, Debt Recovery Appellate Tribunal. Then, after the admission is made, the interim moratorium becomes the final moratorium, and after the moratorium, all the process will happen. At the end, you will have the revocation or the discharge order. Unlike an CIRP process where you will have a resolution plan done and you will have the liquidation in place. Okay. So, who is eligible for making an application for fresh start process? If you see section 78 up from section 80, it is called chapter 2 in chapter 3, chapter 2 in part 3, which is the fresh start process. Fresh start process is a debtor who is unable to pay his debts and fulfill the condition shall be eligible to make an application for discharge. But there are some conditions. His income should not exceed 60,000 rupees. The aggregate value of the assets of the debtor should not exceed 20,000 rupees. And the aggregate value of the qualifying debts would not exceed 35,000 rupees. So, in effect, you will be reading the fresh start process only for your examination, and in all practical circumstances, this fresh start process would not come into play at all. So you will have to read the fresh start process only for the sake of examination. So a person's salary must not be more than 5,000 including his bonus. 5,000 per month including his bonus. Not even I don't know if the minimum salary itself is more than 5,000. And the aggregate value of the assets of the debtor must not be 20,000. Either that man must be a drunkard, or that man must have just entered into practice or employment. If a man is just entering into employment, why should he make an application for fresh start? The aggregate value of the qualifying debt should not be 35,000 rupees. He must have taken some. In the bank audits, you would have seen the goat loan, sheep loan, and the chicken loan and all will be taken. That will only be 35,000 rupees maximum. Invariably, is in order to assist the poor and marginal farmers who will be in a situation to take loans like this, for whom the government is seeking an early exit, okay, and also clear the civil rating, if any, in the process. So the eligibility to make the application is section 80. The debtors who is unable to pay the debtors and fulfill the above conditions, 4 conditions which we had, is entitled to make an application for fresh start. And please remember, he has to make the application all by himself. He cannot use the, I don't know what fees he will pay to the resolution professional also. What is the purpose, the threshold like gross income, etc., practically possible? What is the possible of having in that? As I told the first day itself, during at 4:15 itself, no questions like this can be answered by anybody. If you have to pass the exam, you have to know this. That is all. I also appreciate what is the purpose of having it in that. Yes, I also made a study on that. I also thought about it, and I also discussed with some high-ranking officials in the government of India on this matter, on which I was told that there are n number of small loans in the bank which they are unable to write it off due to various reasons. All this will get away. All the marginal farmer loans and all year on year, so that the farmer can have the loan again next year. I don't know, but he has to make an application, that application and all, he has to fill it up. And he must prove that he is not undischarged dissolvent. He must not own a dwelling unit. He should not even live in a hut. He must live either in the footpath or he must live in a rented house. Rented house for 5,000 rupees of salary. He must not have more than 5,000 rupees of salary, but he must live in a rented house. I don't know what it is. So, but for the purpose of examination, we need to know all this. A fresh start process, insolvency resolution process, there must not be a fresh start process as of him now. And it must not be there within 12 months before the start of this application also. So every year you cannot put a fresh start process taking 35,000 rupees loan. Every year we cannot renew it, but there has to be a 12 months gap between the two. The format of application will be in such form. I think that form must be the most simplest form which should be there. Otherwise, there will be a problem. And it also has a fee which is not prescribed as of now. So the exam question in this, in the previous section, everything is an exam question, examination question here. So we need to be careful. You need to go through this. Since I've been instructed to speed up, I'm not revising it again, so that you have to revise it yourself. The format for application will be prescribed and the fee also will be prescribed there. And please note, there will be a fee. Just because he's having less than 5,000 rupees, just because he's living in the footpath, doesn't mean that there is no fee. He has to pay a fee and also that. Okay. Now we will come to format of application. In the format of application, he has to make a list of all the debts owned by him. That is most important. Even if one debt is wrongly shown, DRT will throw him out of the application and a fresh application would need to be made. all the debts owned by the debtor as on date of the said application, along with the details relating to the amount of each debt, interest payable thereon, the names of the creditors, to all this must not exceed 35,000 rupees. It will all come in our historic films only, wherein all these things will happen less than 35,000 rupees, because I don't know what is it. The interest payable on the debt thereof you have to explain, and the list of securities held under the respect of each debts have to be done. The financial information of the, what financial information he will have, I don't understand, but you may have to give the financial information. Sir, you are reading it for the first time. I am taking this class for the 50th time. Every time I read this, my blood boils. What an impractical way they have done it. And there is no amendment as of now, because individual partnership is yet to be notified. So please understand that. And for the purpose of the examination, you have to say, if I say a white crow is flying, you have to say, yes, a white crow is flying. The financial information of the debtor and his immediate family up to 2 years prior to the date of application. So that has to be there. 2 years prior is an important examination question. It says 5 years prior, 3 years prior. So you have to understand that 2 years prior, you have to make a map of all this in your mind. Only if you make a map of all this in your mind, we will be able to do it. I studied it through mind mapping, where I had written all these things in a way that I was able to recollect and remember it. All these things are examination questions. And the eligibility of making an application or a fresh start process, the debtor must provide the information for up to 2 months before or whatever. If the financial information, immediately our intelligence will say for 5,000 there is no financial information required, will also be one of the options. So we just click that. So we have to be very careful. We have to understand. We have to appreciate this. The application under such subsection 3 shall contain the following information: debtor's personal details. After that, you need to have the reason for making the application. What is the reason for making the application? Escaping from the bank, or writing off the debt from the bank, whatever he has to write, because you have no role in it. You come into the picture late only. So you will have to advise the respective people. In case you are the advisor, advise them, but it must not seem to be advised. So if you are filing 100 applications, you must try to manufacture 100 reasons for that. Otherwise, the DRT will say that the resolution professional has instigated the debtor to file this application, and the application is likely to be rejected, and also the resolution professional is likely to be complained to the IBBA. So need to be careful. And the particulars of any legal proceeding, confirmation that no fresh start was there for 12 months. Confirmation for fresh start is 12 months. His financial details is for 2 years. It is not 24 months and 1 year. It is 12 months and 2 years. So all these things have to be given in the form of an affidavit, before which the application will be filed. So what we have seen now, is the eligibility of making an application and application. Now, as we saw, immediately on filing the application, you have the interim moratorium. Interim moratorium shall file on the date of filing the said application. So there cannot be any action against them. There cannot be any recovery. There cannot be additional interest put during the period of moratorium in relation to all the debts. It is not only for the qualifying debts. It is relation to all the debts and shall cease to have effect on the date of admission or rejection. So until the adjudicating authority, DRT in this case, accepts the application or admits the application or rejects the application, the interim moratorium will continue. So what we'll do, we will file the application and we'll just keep it. We will not make any efforts to make the DRT take it. DRT already in India, he is hard pressed for time. people practicing DRT will appreciate that there are cases 8 years, 10 years pending. So you will happily this person will happily file an application and just sit on it and keep quiet. I don't know what purpose is going to be served by this whole exercise. During the interim moratorium period, no legal action, legal proceeding shall be taken on any of his debts shall be, and all the debts shall be deemed to have paid. No creditor shall initiate any legal action proceeding in respect of such debts. So the only advantage is once he has filed the application, he cannot get any fresh debts at all, and he has to literally slog. Now the fresh start process is coming. So you have to appoint the resolution professional, section 82. You will have to appoint the resolution professional. How will you appoint the resolution professional? Where the resolution professional files the application, adjudicating authority shall seek confirmation that there is no disciplinary proceeding based on the above the RP will be appointed. It is not that the RP is filing this application. The RP will file an application as in Form 2 in the CIRP process you would have read yesterday, that the application the insolvency professional will make an application before the authorized adjudicating authority stating that he is eligible to be appointed. He will request to be appointed on this matter and the RP will be appointed. Where the debtor files an application, the adjudicating authority shall write to the IBBI to nominate the RP within 7 days. Even in the application itself, you can say AB will be my resolution professional or XYZ will be my professional. So such being the case, where the debtor files an application, the AIR will write to the IBBI to nominate the RP within 7 days. Please remember the 7 days, 14 days, 10 days. You have to make a chart. You have to make a chart of all the 7 days, 10 days, 14 days, 28 days, 21 days. All these things, these are appearing. You will have to make a chart and you have to write it yourself. There is no fixed template for that unless each individual writes it in his own way and his own handwriting. It will be very difficult for you to even remember it. So please make a note of all these things. All these 7 day, 14 day, 10 day, and 21 day, 28 day, 12 months, 1 year, 24 months, all those things you will have to write 180 days, 365 days or not. All the dates have to be very importantly seen. If you see in CIRP process, everything will be in multiples of 7. 14 days from the date of application, the adjudicating authority should admit or reject. The 21 days from the admission, you will have to convene a board meeting. You will have to convene the first meeting of the COC. For the COC, you have to do 5 days. Earlier, it was 7 days. It was easier for us to remember, but now it has reduced to 5 days. You have to give the 5 days notice. All those things, you will have to make a note. The days independently, you will have to make a note of all that. Okay, now comes the role of the RP. The RP is appointed. The RP is appointed by the adjudicating authority. All those things happens. After which the application is examined by the RP. The RP shall examine the applicant within 10 days of his appointment. In a CIRP process, within 3 days of his appointment, he must give a public announcement. Here there is no public announcement at all. Immediately where he is appointed, he will make a study within 10 days and submit a report to the adjudicating authority, either recommending acceptance or the rejection of the applicant. It is the fate of the application is with the resolution professional. Resolution professional has to, make a study and he has to recommend whether it can be taken or not. And in that report, he has to file a report to the adjudicating authority. There is no report filed by the interim resolution professional in the CIRP process before 21 days. Only on the 21st day, He files the list of the claims he has received and he makes the voting power, voting range, and he files it before the adjudicating authority before convening the COC meeting. But here, within 10 days he has to file, and the report must contain the qualifying debts and the liability eligible for discharge, which are the liability can be written off. All the chicken loan, all the court loan which he had availed in the bank, and had consumed it during the various festivals, is liability eligible for discharge means all claims. Sorry. His liabilities is eligible for discharge. All the claims made by the debtor. No, we have seen the excluded liabilities now. Excluded liabilities are excluded. The other liabilities, he will make a report. All the liabilities which are eligible for discharge only, they are not discharged. Eligible for discharge means which can be written off. Whichever liabilities can be written off by the respective lenders, the resolution professional will make a list. Resolution professional may call for such other information or explanation in connection with the application as may be required from the debtor, or any other person or such person shall furnish the explanation within 7 days of receipt of the request. Again, here 10 days, and now you have to remember another 7 days is to any other person, including the debtor, any clarification which you want, you have to go. The 7 days, the sanctity of the 7 days is the RP has to examine the application within 10 days. So obviously, he'll have to do it. He'll have to obtain it all within 7 days, and in the balance 3 days, he'll be able to do it. Does anybody want a break? Shall we take a bio break or a break? Now we are in 5:41. We will assemble at 5:50. Is it all right?
Sir, 5 minutes is enough, Ramana sir.
Huh?
5:46 should be enough.
Okay, sir. We will assemble at 5:46, sir. Okay. The chairman's ruling is the final. The quizmaster decision.
I want more time to be spent for the members actually.
No. Yes. I understand. So we will just stop it here. And from the next one, we have even more interesting things to come about. Slowly the film will unfold. Slowly we'll see some fight, songs and all. We will take a break. Thank you. Friends, are we back? Okay. The resolution professional shall examine within 10 days of his appointment, and he has to submit it to the adjudicating authority, who is the DRT, and his report must contain the qualifying debts and the debts, the liabilities which are eligible for discharge. And such information within 7 days has to be provided to him as he is requesting or asking for. Now, during the examination, the resolution professional shall presume that the debtor is unable to pay his debt at the date of application if, in his opinion, the information supplied in the application indicates that the debtor is unable to pay his debts and the resolution professional has got no reason to believe that the information is incorrect or incomplete. This is a provision in order to safeguard the resolution professional, because tomorrow he must not be visited with the allegation that he has made it for whatever reason without appreciating or without acknowledging the fact of the the debtor. And there is no reason to believe that he has supplied wrong information, and he has reason to believe that there is no change in the financial circumstance. He has not got any lottery, he has not got any bigger job or whatever it is, and he is unable to pay his debts. He has to satisfy himself. And where he does not satisfy, he has all the liberty to reject the application and recommend rejection. The resolution professional shall record the reason for recommending the acceptance or rejection and report it to the adjudicating authority, and shall give a copy of the report to the debtor. This is most important here. Again, an examination question. All of us will feel, why should he give a copy of it to the debtor? He can just reject it and keep quiet. No, there has to be a copy of the rejection letter given to the debtor. I don't know how many resolution professional will spend 10 days and ultimately say, I don't want this job. I'm at loss to understand. But be it as it may, you need to indulge in that. Now, the admission or the rejection of the application by the adjudicating authority. Here we will go back to the this thing and see. So what has happened? Now we are ready. Now we have seen the application to be filed, interim moratorium, appointment. The RP has made a report to the adjudicating authority. RP has reviewed the application and recommended the admission or rejection. And sorry, from here it has to go. Okay. Resolution professional, he has given a report to the adjudicating authority. Now the adjudicating authority will say whether the admission is there or not, and thereafter the moratorium is created. So we have seen up to 83, we have seen 84. The adjudicating authority may within 14 days. For adjudicating authority to escalate to IBBA, it's always 14 days. It is 14 days in CIRP also. It is 14 days here also. Adjudicating authority to IBBA, from IBBA to adjudicating authority, again it will take 10 days. Here the IBBA must within 10 days. You have seen here that adjudicating IBBA will inform within 10 days. Okay, RP shall be appointed within 10 days from receiving the direction from IBBA. Yes. The applications and state the amount which has been accepted as qualifying debt. All these things has been recommended by the RP. You understand, for discharge of the purpose and for the fresh start order. A copy of the order passed by the adjudicating authority along with the copy of application shall be provided to the creditors. This copy of the order is admitting the application shall be provided to the creditor, all the creditors maintained within 7 days of passing the order. Again, all these 7 days, 10 days, please make a note and remember it. Effects of admission of application. Immediately on admission of the application, you have what is called as a moratorium. Once the moratorium is there, there cannot be any pending legal action with the state. Creditor shall not initiate any. The same thing as we saw in the interim moratorium also is applicable here. There is no difference between what is the moratorium in an interim application and interim moratorium on the filing of the application, and the final moratorium on the admission of the application. Filing of the application, interim moratorium. Admission of the application, moratorium. During the moratorium period, you shall not act as director of any company. I'm not able to envisage a situation how a man earning 5,000 rupees, less than 5,000 rupees, will be appointed as a director in any company unless he's a binami or trying to do something smart and mischievous, whatever it is. He cannot do. He cannot dispose of or alienate any of his assets. What assets he has? We have seen that he has assets of maximum 20,000 rupees only. What he should not dispose that assets also. He must inform his business partners. For 5,000 rupees earning a month, if he has a business partner, I don't know what kind of business they are doing. So all these things you have to remember. Again, I said for example, and be requisite for the be required to inform prior to entering of any financial or commercial transaction. Whatever commercial transactions, I know all of you must be laughing because in the physical classes I used to have a roar of laughter here. It is the comedy scene in any of the movies. Okay, he must notify to the central government either individually or jointly that is undergoing a fresh start process. My God. And disclose the name under which he is entering into the business transaction, etc., etc. He must not travel outside India. Again, a very big comedy. Effect of admission of the application in fresh start product. He must not travel outside India except with the permission of the adjudicating authority. God save. The period of moratorium is 180 days, the same as what was there initially for CIRP. CIRP first it was 170 plus 90 became 180 plus 90 became 270. Then after the amendment, it became 330, including all the time spent for the purpose of litigation, etc., etc. It became 330 days. All of us are aware of that. So the moratorium will be for 180 days, beginning the date of admission. It is not the date of filing of the application. It is the date of admission from the date from the day the adjudicating authority, which is DRT, has admitted the application. From that, it is 180 days. And if there are any objections, the creditors obviously will have a number of objections. If they have any objection, within 10 days, they have to make this on the following ground: the debt is either included or not included, or the correctness of the qualifying debt. Please understand, these two are the only conditions involved for the purpose of the objection by the creditor. Your examination question will include these two: inclusion of a debt as a qualifying debt, including the incorrectness of the same. Will be one option, and the other options will be including all those, none of the most. So please be careful. This is an examination question. Section 86, objection by a creditor during a fresh start process is an examination question. Please make a note of it. A creditor may file an objection in the way of application to the resolution professional. He should not file the application of the objection to the adjudicating authority. As I said earlier, the whole hand-holding, the whole mentoring, the whole orchestration of the whole process is done by our good friend, the resolution professional only. The resolution professional shall examine, and either he can reject or accept or reject it within 10 days. Everything must happen within 10 days. Application against the RP. Now, after the RP says, I will not accept, our debtor or the creditor, if he accepts, the debtor will go on an appeal. If he does not accept, the creditor will go on an appeal. Within 10 days of such an order, he can make an application to the AA challenging the action of the resolution professional with respect to rejecting the application in case of a creditor or accepting the application in case of a debtor to the adjudicating authority, namely the DRP. The resolution professional has not given opportunity. The resolution professional has colluded. Both the parties can say, debtor can say, the resolution professional has colluded with the creditor and accepted the claim. The creditor will say, the resolution professional has colluded with the debtor and rejected his claim. However it is, the resolution professional will be blamed that the resolution has not complied with the requirements of Section 86. Section 86, we saw what are the conditions required. The conditions required under Section 86 have to be followed. Those things, if they are not followed, as I said, inclusion, exclusion, the correctness, all those things is one of the reasons for filing the application before the AA. This is again an examination question. Resolution professional has not complied with the requirements of section. They will say 85, 84, 88, 87. You need to check up whether 86 is there or not. You have to remember this one. Application against the decision of the RP. Again, the adjudicating authority shall decide within 14 days. One more 14 days is coming, and make an order where the application has been allowed by the AA. It shall forward its order to the board. The board here means IBBI. You will know it. You will know, I think on 30th we have the classes where all these definitions will be taken. A board is a board. IBBI is the board. Insolvency and Bankruptcy Board of India is commonly and very in a short format known as the board. Forward to the board, and the board may take such action as may be required against the resolution professional. If the adjudicate, yes, where there is any action to be taken against the resolution professional, or if it has been proved that he has not given opportunity, he has colluded, and he has not complied with the various requirements of Section 86, the board may, the adjudicating authority may write to the board, and such action will be taken against the resolution professional. Now we have to come back to see what is a qualifying debt. In fact, I think there was one question by somebody asking me what is a qualifying debt. Isn't it not? Who asked the question? Maybe before I left or something. I think somebody asked me a question on qualifying debt. Okay, whatever it is. What is a qualifying debt? We have seen only the debts which are disqualified, like for example, the loan, the housing loan, etc., etc. I think we have seen the qualifying debt also. We have explained what the qualifying debt is. Qualifying debt is interest, any sum, either immediately or the action does not include excluded debt, and 3 months prior to the application of the fresh start product. I think we have already seen it. The repeat is because it is in Section 87. Okay, I think this is a wrong thing somewhere. Okay, for whatever reason. Qualifying debt we have seen, and now we go into the general duties of a debtor. What are the general duties of the debtor? He will make available to the RP all information relating to his affairs, attend meetings, and comply with the request of the RP in relation to the FSP. So this is what. Please elaborate fresh start process. We are only doing fresh start process here, sir. Inform the resolution professional of any errors, any mistakes, any changes in the financial circumstance. Because please remember, the resolution plan is prepared by the debtor in assistance with, in association with the RP. So he has to share all the information. That is the first duty of the debtor. And there can be situations of replacing the resolution professional also, where the debtor or the creditor is opinion that he needs to be replaced. There has been application to the adjudicating authority, interlocutor application, and that application will decide whether he should continue or not. And wherever there is a complaint against the resolution professional, please remember the respective adjudicating authorities, either in a CIRP or in a PRP, will have to make a reference to the board. Will have to make the reference to the board for replacement of the RP. Adjudicating authority shall appoint other resolution professional for the purpose of fresh start on the basis of the recommendation they receive from the board. Here, nobody can insert that, 1%, either the creditor, neither the creditor nor the debtor can recommend somebody to be the RP here. Where there is a change of RP, it happens a third person by the panel which is being held by IBC. Those people will only replace him. Replacement of resolution professional can appoint other resolution professional for the purpose of, on the basis of recommendation of the board. AA will appoint, AA will give direction to the replaced RP, our friend who has been replaced as RP, that he must share all information and cooperate. This is there everywhere, whether change of RP for CRP, PRP, liquidation, bankruptcy process, for everything, where there is a replacement of RP, he must share all the information with the new professional, and he must cooperate with the new professional as may be required. So there has to be a seamless transition from one RP to the other, is the intention of the legislature here. When can an RP file apply for an erection? The RP can make a direction. The RP shall apply to the AA to require the debtor to comply with the restrictions in Code 85.3, where we have seen not to dispose, alienate our assets or travel abroad, all those things wherever he has, not to act as director, inform his business partner, transaction, disclose the name in which he enters into business, not travel outside India, all those things are 85.3. Wherever there are non-compliances with that, it is the duty of the RP to inform the AA and also seek directions from the AA, either to make the debtor comply or to punish the debtor. Compliance with the duty of debtors as per the 88. If the debtor is not appearing or is not making himself available for the meetings or any seeking information, he has to do it. He can also apply to the adjudicating authority for any other matter other than 85-86, for which no provision has been made. It is equivalent to section number 60, subsection 5. Please read 60, subsection 5 with respect to CIRP process, wherein for any other matter, for example, the debtor is threatening the RP that I will kidnap you, that I will kill you, all those threats also, he can apply under section 90 to the adjudicating authority seeking protection or seeking direction from the adjudicating authority as to what must be his process. I'm just seeing the chat box once again. LLP is in bankruptcy. Whether all the LLP is being to bankrupt? Yes, appellate authority for AA is the Debt Recovery Appellate Tribunal. DRAT is the appellate authority. Application for revocation order. The resolution professional may also submit an application seeking revocation of the order admitting the application, because under section 84 he would have made a recommendation and it would have been admitted if there are any blatant errors or any other errors which has come to his notice only now, because understand the resolution professional will accept the application and will presume that he has the debtor has given all the information to him. Such being the case, he can make an application if there's any change in the financial circumstances. If he receives an increment of 100 rupees over, from 5,000 rupees, our man is getting 5,100, the RP will file for the revocation. Isn't it not? He cannot come into the limit at all. So from 500 to from 5,000 to 5,100 in the next month, he has to close the matter and he has to apply for, he has to recommend for revocation. If there is a change in the financial circumstance, non-compliance of a debtor of the restriction, whatever, he flies abroad without informing AA, he can apply for it. If the debtors acted in a malafide manner or willfully claim to comply with the provision, obviously it can be revoked. Adjudicating authority within 14 days, the next 14 days is coming, may order to admit or reject the application, or the moratorium and the fresh start process will cease to effect if the order of revocation is passed. And the order of revocation under section will also be sent to the board. Wherever we are actually sending the the AA is actually sending to the board on any matters of the proprietary of the resolution professional. Similarly, wherever there is an order passed, that order is also shared with the board. The board will use the order for the statistical purposes, for research purposes, and also try to upload it in their website, which is part of this. Discharge and effect. Now slowly it is being discharged. The resolution professional shall prepare a final list of the qualifying debts and submit to the adjudicating authority within 7 days, and the adjudicating authority shall pass the discharge order and end the moratorium for discharge from the qualifying debts maintained in the test. Now the adjudicating authority shall discharge from the following liabilities. Penalties. Penalty paid by the debtor is forming part of the excluded debts. Similarly, penalty in respect of qualifying debts from the date of application till the date of discharge is waived, is also discharged. Interest including penal interest for the qualifying debts, discharged. Any other sum owed under the contract of the qualifying debts from the date, it is only from the date of application to the date of discharge order. Please remember, only from the date of application to the date of discharge order, you have all these, discharge effects, and it is excluded. But for other things, it will be included. This is also an examination question. It will actually confuse in a way that you will have to remember this properly. From the date of application till the date of discharge order, it will be discharged in the case of a fresh start process. The discharge order shall not discharge the debt from any debt and liability not included. Please understand, only for the qualifying debts, all these advantages are there. For any debts which are not qualified, it will not happen. It will not discharge, not included. Discharge order shall not discharge any other person. So the man has 5,000 rupees, his wife is earning 4,000 rupees. So when he discharges, even my family members are discharged. No, it is only one-to-one. Discharge order shall not discharge any other person from liability in respect of the qualifying debts. Assuming there is a 35,000 joint debt taken by A and B. A makes an application, A is discharged. B does not make the application, B is still liable to make the repayment. Please compare it with the definition of associates. In the definition of associates, we have seen that in the definition of associates, we see the spouse of the partners are also included as associates. But while we are discharging, this individual person is not being, the individual is only discharged and no other person along with him is ever discharged. The resolution professional shall perform his functions and duties in compliance with the code as provided by the code. I don't know what is the fee the resolution professional will receive at the end of the day. Maybe when you guys pass out, this part 3 will come out and you will start making some money. I am at loss to understand where does the economics and dynamics of the resolution profession is there in this kind of an situation, but whatever it is, we need to wait and watch. So with this, we come to an end of the what you call the quick start order, fresh start process. And if there are any questions, we'll take. I'll give another 5 minutes and 6:20, 6:19. We will take up the next thing, which is the most important thing, is the insolvency resolution process from 94 to section 120. I think we will do it in one marathon session. If there are any clarifications, you can please write in the chat box. Until such time, I will have my hot cup of tea.
Ramana Kumar, sir.
Yes, sir, I'm there.
Okay. No, just wanted to reach it.
Yeah. If there are any clarifications, because we have taken a fast.
Okay.
No, the fresh start process has not yet been notified, sir, Venkateshan, sir. It has not yet been notified by the government. So there is no single fresh start process. Even if it is notified, I am at loss to understand with the present conditions whether there will be any fresh start process or not. I hope you will appreciate this point with me. application. You tell me, sir, it is an examination question, Mr. Martin Selvaraj. This is actually an examination question. Excellent. Moratorium in a fresh start process starts from the admission of the application. Interim moratorium only starts from the submission of the application. Please understand, there is one submission of application, there is one acceptance of application, and there is an order on the application being admitted. There are three different situations. On submission of the application, if you have the acknowledgement copy, that is why I said very clearly, if you have the acknowledgement copy, the interim moratorium is triggered, and on admission, the final moratorium is triggered. Okay. Absolutely. The property will be taken over by the person giving the collateral, taking the collateral security now. Any dwelling is given as collateral security by the guarantor can be auctioned in case of failure of principal. Yes. But now that is out of syllabus now, we are not looking into it. We will come in the next presentation. We will come in there. Venkatesan sir, you have asked me a question whether even if it is notified, do you feel this is going to be an economic class? This is going to be a class only for an examination. You just treat it as an examination class and be done away with it. Chairman, facilitate to view all questions. No, there are some questions written to me privately, sir. You will not be able to see it. That is why I am reading the question and then providing the answer. If you still want the chairman to facilitate the question, let him do it, sir. No problem.
Ramana sir, there are some questions which are there, which I have actually compiled based on the Q&A. We'll take it up in the end. If there is repetition, you can tell that you have already answered.
Absolutely no problem. You can take it now itself, sir. Show it to me.
Okay, then 1 second, sir. I'll have to take the presenter rights and Selva, if you can give me presenter rights, I will flash the questions on the screen.
One minute. Done now.
Sir, once the screen is visible, let me know. Is it visible, sir?
Yes, sir. It is visible now.
Yeah.
Can IP proceedings be initiated against individuals?
So there's one above that. Why the word limited used in limited insolvency examination?
Sir, we can ask them, sir. We can ask IBBA. There is an IBBA website there. You just write to them, they will answer. I am only concerned about you passing the exam, sir. Certain qualitative questions and opinions. I am not here to provide any opinions for the simple reason, sir. The syllabus of the session is not to provide opinions. Maybe on a passing remark, jovially, I would say all that the chicken loan, the goat loan and all for us to understand. But, I will not provide any opinion as of now. Okay. Can IP proceeding be initiated against any individual or a partnership firm? Yes. The whole part 3 is on individual and partnership firm only, but it is yet to be. Announced, or it is yet to be notified. Is partner, spouse, relative also an associate? Okay, please take the definition. Please take the definition, section 79 within brackets to Bhuvaneshwari madam. Please read 2D, a person who is a spouse or a relative of any person with whom the debtor is in partnership. Spouse of the partnership. Spouse relative. Spouse relative is not included. You are right. Spouse relative is not included. Correct. LLP is in bankruptcy, whether all partners. Yes. Once the LLP is dragged, all the partners are also dragged. What is the difference between bankrupt and bankruptcy? Bankrupt and bankruptcy. Bankrupt is in subsection 3. Bankrupt or debtor who is adjudicated as a bankrupt by a bankruptcy order under section 126. We have seen that. If you are adjudged as a bankrupt, it is bankrupt. The bankruptcy is the state of being bankrupt. Bankruptcy is the process of making one person a bankrupt. So during interim moratorium, legal action can be initiated by the debtor. Legal action can be initiated by the debtor to provide to safeguard his assets. The legal action can be initiated by the debtor to recover his money, everything. But with a 5,000 rupees salary, no head, no roof over his head, do you think he will enter into any legal action? As per this prescribed mark allocation, 66 is for IBC. Is there any allocation further so that more questions are here? No, sir. From this 66 marks in IBC includes all the sections in IBC and the regulations also. So you have to be very careful in calculating excluded debts, whether personal guarantee given by the debtor or the loan taken by his relative. Personal guarantee we are coming separately in the next presentation, so we will wait for some time. 10-year post qualification, does it mean should be in practice? Can it be in employment? I think if you read the thing, for a person in employment, he has to be for 15 years, I think. But now they might have changed, I don't know. But 10-year post qualification is just for practice alone.
I think Ramana sir, it is 10 years at par for both practice as well as employment.
Both practice and industry, huh? Excellent.
Yes.
So that's a very good thing. I think it is a representation made by the bankers and other people in the financial sector, which I think some amendment has come. Excellent. Okay. What is the 50-hour training after qualification? It is one way of making money, sir. Leave it off. Next question, sir. Can you please, insurance policy, sir. Insurance policy, unencumbered insurance policy. If you have taken loan on insurance policy, that will be covered. Okay. Corporate guarantor, we will see it later. What is the maximum qualifier limit? 35. Do we need to elaborate process? It is a theoretical question, sir. You need to read the fresh start process for writing the exam. So we will leave it at it. I have also made my comments very clearly. I have also, in unequivocal terms, I have also expressed that this whole fresh start process is for your examination. To freshly start your examination, you can read fresh start process. Any other questions, sir? 11 questions over here.
We'll take your further questions in the end, sir. As of now, we have covered all.
Excellent, sir. Thank you, sir. I really appreciate all the interactions by the members, which is really actually heartening to see. I'm just sitting in some dingy room in my office and I'm making the presentation. I don't know whether people are really observing or not. I'm glad to know that almost everybody are observing, and I really appreciate each one of you. At least my chairman is there. With his ever smiling face, ever smiling, he's there. I'm happy. Okay. Oh, now we come to the. Now it is the in the film interval is over. Now we are coming to the second half of the film, in which we will actually see what is happening. All the twists and turns will start happening from section 94. We will look at it. It's very interesting. And now the insolvency resolution process for individuals and partnership firms will actually take place now, in the sense that, there is real action in this. But you will appreciate that what we read in our previous one, we have total of 61 slides here. What we studied in the previous two sessions or the presentations will be equally important here for us to have a look at. Okay, so what we have seen, part 3 is the insolvency resolution process for individual and partnership firm. Chapter 1 is the preliminary, which we saw section 78 and 79 for 1 hour 15 minutes. We spent on those two sections, and then we saw section 80 to 93. 80 to 93 section we saw again in about, say, 1 hour's time, because I was asked to go a bit speed up and do. Yes, accepted. We do it. Now we'll go into the insolvency resolution process, which is 94 to 120. I have just made a map of it. After this, what will happen is you will have the bankruptcy order. What are the 3 sections in which bankruptcy order will be there? 92, 119 and 127 or something. Isn't it not? The 3 sections. Please remember that. I'll open the chat box so that if anybody's typing it also, I can see it. Yes. And after that, we have the administration. It is equivalent to the liquidation for a CIRP process. I think all this will be taken. Chapter 4, 5 and 6 will be taken the last day. And we will have, I think we should have time. We have about 1.5 hours time. I think we should be able to complete 94 to 120 within that. So what happens? First, we have to make the application before the adjudicating authority, and there has to be a public notice claims registration, and there has to be an appointment and all aspects with respect to our RP and the committee of creditors and the repayment plan. Repayment plan is akin to the resolution plan which we have in CIRP. Please remember that. And it is a very important part. Chapter 3. You can expect at least 25 marks from here with respect to all the issues covered. So I think we have to study this threadbare, and every nook and corner we need to study. So this is the process flow which we have. Yes, and 138, you are right. 92, 119, 138. Yes, I can remember it. Thank you, Murugavel sir. I tried to contact you before the program. You didn't pick up the phone. It's all right. But it is 92, 119, 138. Isn't it not? So please remember that. The 3 where you will have orders from adjudicating authority, which is DRP. Okay. Now we'll come back to this. Excellent. Excellent. Thank you. Application filed by the debtor or the creditor. Please actually compare it with the slide which we made for the fresh start process. Interim moratorium commences. Yes, both these things are identical. Appointment of and replacement of resolution professional happens. Yes, it happens. Resolution professional is given the copy of the application. Yes, it happens. There it was 3 blocks. Here it is 4. That is the only difference as of now. RP reviews the application and recommends acceptance or rejections. RP presents a report. Admission from admission of the application from adjudicating authority. Here also the adjudicating authority is the DRT. Moratorium. Now comes the change. After moratorium, you give a public notice. A public notice happens like a public announcement, which is called a public announcement in a CIRP process. In an individual partnership situation, it is called as public notice. After giving the public notice only, you create a preparation of list of creditors. Why? Why we are giving a public notice here? In a fresh start process, that fellow who is earning 5,000 rupees, who doesn't have a roof over his head and who has assets less than 20,000 rupees, will give you a schedule of his assets and liabilities himself. But in this case, it is not so. Being individual and partnership forms, you need to give public notice to see whether the public are involved in are also involved in this matter, and they have to give big claims as we receive claims in the CIRP process. Then you prepare the list of creditors, then the repayment plan is prepared, then the report of the RP on the repayment plan. In the situation of a fresh start process, there is no report of the RP on the repayment plan. There is a report, general report on all matters, including the cooperation, everything. But in this, there is a specific report made by the RP on the repayment plan, after which there is a meeting of creditor to review them. And for that 35,000 rupee loan, there is no meeting of creditor and all. Immediately on recommendation by the resolution professional, the adjudicating authority, which is the BRT, will set the man free. Here it is not so. You have the meeting of the creditor, and then there is a premature termination of a plan, especially like a situation of a resolution plan which is not honored, which is defective, which is not accepted by everybody after this thing, which is not been executable, etc., etc. After that, we have the discharge order, either discharging the debtor or revoking the admission order, as the case may be. This is the process flow. If you have not written the process flow, please write the process flow in the way you want. It has to be written, and in each of the process flow, you will have to write the respective sections and study. What I would recommend is write the process flow, one heading in one page in your notebook, and just fill it up as we go through in the in the other slides, or afterwards looking at the slides. Please make a personal note of it. Unless you write down, friends, please understand there are templates available in the Google for all the 14 days, 10 days, 7 days, etc., etc. All those things are available. You cannot mug them up. Please write them yourself. Only then you will understand, and you will not forget it in the examination. So the process of insolvency process can either be by the debtor or the creditor. One important difference is asked in the examination in whose asset for a fresh start process. It is only by the individual, but here it is either by the debtor or the creditor. Am I right in telling that? Am I right in telling that a fresh start process is only by the debtor? Yes, it is. It is only by the debtor who is unable to repay. It is like Section 10. Yes, it is like a Section 10 application in a CIRP, where the corporate debtor only files it. Here it is the debtor who files it. Whereas in a insolvency resolution process, it can be filed by the creditor also. Please understand that. That is the main difference, because there are questions wherein you will have to differentiate between a fresh start process and a resolution process, for which you need to know what happens in the fresh start process. Compulsorily you need to know, because please take at least 5 to 6 marks on this difference. It will surely come in some form or the other. We are unable to predict which are the questions that will exactly come. Obviously, that is the reason why we have a professional course like this. But we need to be prepared. If you are prepared on that, we will be able to do it. This is the way, my friends, I studied for the examination in 2017, September I completed. I studied for the examination only in this form. I cracked everything. I compared each and every section in order to remember wherever it comes. So everything was mapped in my mind in such a way that I was able to complete the examination in 25 minutes. 90 minutes examination, I completed it in 25 minutes and I got 68%. I'm not trying to boast or trying to blare myself, because this is all history, and we are much fast from that. But what I want to impress upon this group is you need to crack it in this way in order to have a very comfortable. I want each one of you to crack it in the first instance. I want each one of you to clear it in your first attempt with a mark which is more than 65 or 66. If you get 70, 80, excellent. But I want all of you to be so confident that when you write the exam, you are sure to pass it. Before you see the result in the screen, you should be able to understand that you have cleared it. That is the way I want all of you to do it, and that is the intent of this course as well. Okay, first we will see what happens from the debtor. The debtor has committed a default. Application can either be through a resolution professional or can be personally, it can be done. In the fresh start process, what happens? Please compare. Once you start comparing the two, you will not forget. Where debtor is a partner of a firm, there was a question raised. Such debtor shall not apply under this chapter to the adjudicating authority in respect of the firm unless all or a majority of the firm file the application jointly. So it is very important. All the partners or majority of the partners. Again, is a question. All or majority is one option. The other option will be all. The other option will be majority. And the last option will be as decided by the partnership deed. Please understand, there is no partnership deed which we have, which will say that we will file for bankruptcy together. Please understand that. So that is not a right option at all. But the question will confuse us like that in order to have the various alternatives. So please be careful about it. It can, where all or majority of the partners, both has to be there, all or. There cannot be a situation where it is all and. So it is only all or. The application cannot be for excluded debts. What are the excluded debts we saw? We saw excluded debts earlier. Try to recollect what are the excluded debts so that we may excluded debt is section 15. Any fine, damages due to negligence, etc., liability to pay any maintenance for the person for or in force. Somebody asked, divorce spouse, somebody asked. So if there is maintenance to be paid to the divorce spouse, it is an excluded debt. Liability for a student loan. Please understand all these things have to be excluded even in case of a partnership firm and all the partners or partners have to do it. Who cannot apply? A debtor shall not be made to apply if he is undergoing a fresh start process. There for 35,000 rupees he is undergoing a fresh start process and now he cannot apply. Who is undergoing an insolvency resolution process under the same sections he is undergoing, he cannot do it again. Or a bankruptcy process. If he is undergoing a bankruptcy process also, he cannot do. Immediately one question should come in the chat box. What happens if he is undergoing a CIRP process? Please understand, section 2, subsection 31 of the income tax also very clearly treats the company as a distinct person. It also treats the partnership as a distinct person. But here the partners have unlimited liability, because of which they have to, all of them have to take part. But with respect to a CIRP, it is only on the company. The directors individually, even if they undergo a CIRP process, the director can make an application under the insolvency resolution process. If an application under this chapter has been admitted in respect of the debtor during the last 12 months, exactly as in the case of the fresh start process. 12 months for the application, 24 months for the accounts. Please remember, in fresh start process, 12 months is this thing, that is 24 months. Application referred shall be in form as may be prescribed. It is not prescribed. So please wait. What is the difference between IRP and bankruptcy? IRP is is interim resolution professional, sir. Fresh start can also be RP. Yes, fresh start can also be by RP under 82. Fresh start can also be by RP under the 82. Section 82, subsection 3, Pramoji, section 82, subsection 3 says, where an application under section 80 is filed by the debtor himself and not through the resolution professional, the adjudicating authority shall direct the board. Okay. That does it say that it can be through the resolution professional. 82, where an application 80 is filed by the debtor through a resolution professional. Okay, fine. Okay, there are instances where he can file through the resolution professional, but even if he files it through a resolution professional, the application is deemed to be prepared by the debtor only. Yes. Insolvency resolution process, IRP. I don't still understand, Martin Selvaraj. What is the difference between IRP and bankruptcy? IRP and bankruptcy are two different things altogether, sir. Insolvency resolution process. In insolvency resolution process, do you have an IRP? You have an RP straight, no? Where do you have an IRP here, sir? Appointment, replacement of RP, RP given a copy, RP reviews, RP presents a report, admission with this thing. There you don't have IRP concept at all here. Okay, sir. So these people can't apply. And now we will come to an insolvency resolution process. Okay, you are calling insolvency resolution process as bad. Okay. Insolvency resolution process is like your CIRP. Bankruptcy is like your liquidation, sir. In the CRP process, we have CRP process and liquidation. Yesterday you would have seen the CRP process, and liquidation will come later, which we saw in the first one. No, here we saw bankruptcy order is the liquidation order. Administration and distribution estate of bankrupt is the liquidation process the liquidator will do. So the bankruptcy trustee which we saw is the liquidator, akin to the liquidator. Am I clear, sir? I'm sorry, I took some time to understand the question, but appreciate it. Thank you, Martin ji. Now we come to the initiation of the process by the creditor. Draw a parallel to section 7, section 9 of the CRP process, where a creditor may apply by himself or jointly with other creditors, no problem, or through an RP to an AA for insolving and submitting an application. So a creditor can make an application. A creditor may apply in relation to any partnership debt owned for initiating against one or more partners or the firm, because the partners are all jointly and severally liable to each other and the firm. Isn't it not? We have read it. So such being the case, the creditor may make it against the firm or against any one or all the partners, no problem. Where an application has been made against one partner of the firm and there another application is made against another, they shall be transferred to the AA in the first mentioned application. There is a concept. Sorry, one second. Where the first application has been admitted by, or the application has been made by a creditor, say in Chennai, DRT. And against this same firm, another application is made in, say, Hyderabad DRT. So the Hyderabad AAA will transfer the application to the Chennai AAA. It is the long and short of it. Where an application has been made by one partner against one partner in a firm, any other application against any other partner of the same firm shall be presented in or transferred to the adjudicating authority of the first mentioned application pending for adjudication, and such AA may give such direction to consolidate all the applications. Obviously, all the applications have to be consolidated in order to meet, and please understand it, it is a very simple concept. Again, examination question, every phrase here, every word here is an examination question. Document for creditor initiation. First, he must show what is the proof of debtor, proof of debts owned, failure by the debtor to pay a debt within 14 days. First, he has to make the debt owed by the debtor to the creditor by submitting an application for IRP as on the date of application, the failure of the debtor to pay and relevant evidence for default. So, you have to take a CIRP process, you make a notice, and within 14 days, if there is no money paid on the notice, we will initiate action against them. Relevant evidence for default of the non-payment of debt is available with us. Again, the application will be in such form, blah, 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 blah. The creditor shall also provide a copy of the application made to the debtor. So what will happen here? So what the act is envisaging is the debtor will get all the copies of application. Where there are more than one application, it will be the duty of the debtor to somehow have them clubbed in order to close the matter. But whether the debtor will do that is a $1 million question which we can ask. Impact of filing the application, interim moratorium comes, the same interim moratorium which we saw in that. So we will be skipping it. Exclusion and inclusion, where an application has been made in relation to a firm, the interim moratorium shall operate against all the partners of the firm as on the date of application. The provision of this shall not apply transactions as may be notified by the central government. For example, payment of GST, advance tax, etc., etc. All these things will not be taken into account, and where you have to pay the EMIs and loans for term loans, etc. The financial sector regulator will be sought, and as per the instructions, it will happen. Again, as we saw in the last one, the same thing. Appointment of RP, section 87, and the other section also, which we saw in the fresh start process. Almost the same, almost identical. So you can just have a look at it. Again, the replacement of RP, where the debtor or the creditor is opinion that RP appointed under is required to be replaced, he may apply to the AA. AA is DRT. Again, within 7 days, he has to refer to the board. The board within 10 days will have to have answered to the AA and recommend the name of RP, where no disciplinary proceedings are pending. Your slides are not moving on the screen. It is moving on my screen, sir. Is it still not moving? Huh?
Now it is moving, sir. Moving. It is moving.
For me, it was moving always.
No, it is moving, Ramana, sir. It is moving.
Sorry?
It is moving. It is moving. 20 seconds slide is there on the screen now.
Okay. Super. So replacement happens, and similarly to the fresh start, the RP will examine the application, approval or rejected will be there, and what is the additional thing in section 95? Where the application has been filed under 95, the resolution professional may require the debtor to prove repayment of the debt as claimed and unclaimed. So evidence of electronic transfer can be there, evidence of encashment can be there, a signed acknowledgement by the creditor can be there. All those things have to be there in case the debtor claims that he has made the payment to the respective creditor. He has to put. His situation is not there in the fresh start process, remember. And the report of the professional where the debt for which application has been made, has been filed by the creditor is registered in the information utility, maybe asked yesterday whether you saw information utility or not, I don't know. This information utility is the one which will capture all. It is like we are all a group of chartered accountants, so we can say it is like our AAR report. The income tax will have a AAR report now. It is like the AAR report, which will have all the information with respect to that PAN number. Similarly, information utility is envisaged as a body which will capture all the loans, all the repayment schedules, whether it has been made properly or not, all the information with respect to the debtor, which will be captured, and you can access the information utility on payment of a fee, and it can be done. Now almost all the banks are part of the information utility. In fact, all the banks are sponsored and created an information utility. So whenever a loan is sanctioned, it is also mapped in the information utility. So if you have to give a fresh loan, all you need to do is you will have a separate number. I don't know what kind of number it is, whether it is your PAN number or any specific number which we will have. That number will be keyed into the information utility, and all the aspect with respect to all the loans taken, or everything will be shown just like our AAR report, and it will be used. So where the debt is on an application made by the creditor is registered with the information utility, the debtor shall not be entitled to dispute the validity. So if you have taken a loan from a bank and that is entered into the information utility, you cannot say I have not taken the loan at all. Not possible. For the purpose of examining an application, RP may seek further information or explanation in connection with the application from the debtor. Obviously, he has to cooperate, he has to provide all the information, etc., etc. The resolution professional shall examine the application and ascertain that the application satisfies the requirement of 94 or 95. Again, it is an examination question. 94 or 95, 95 or 96, 93 or 94, or all of the above. So please be careful about it. The application has provided information and explanation sought by the RP. So whatever, and on examination report, he will recommend the acceptance or rejection to the AA. When the RP finds that the debtor is eligible for a fresh start under Chapter 2, RP shall submit a report recommending the application. It is a very, very remote chance. According to me, it is only in theory, only for the purpose of, only for filling up the purpose of Section 99, it is available. As in a normal application, the RP comes to know or identifies that this fellow is eligible for a fresh start process. He will make an application accordingly. I don't know how it is possible, but it is possible for the purpose of the section. The RP shall record the reason for recommending the acceptance or rejection. The RP shall give a copy to the debtor or to the creditor as the case may be, whoever has made it. Say, for example, the application is made by the creditor, and during the scrutiny, the RP finds that for the application made by the creditor, the debtor is eligible for a fresh start. He can recommend a fresh start to the AA, is what is termed, and he can treat that application which is filed by the creditor as an application under Section 81. So 94 and 81 are the contra sections we need to remember. Admission or rejection of the application, the AA within 14 days, again 14 days, earlier it was 10 days. 10 days is asking the board for information. 14 days for itself to pass the order, shall pass the order, either admitting or rejecting the application. In the AA admits, it may on the request of the RP issue instruction for the purpose of conducting negotiations between the debtor and creditor for arriving at the repayment plan. The AA shall provide a copy of the order to the board. Yes, everything will be happening. And they have to a copy of the order is also provided to the respective creditors who have applied for. Section 100. Now we'll see what happens if it is rejected. In case it is rejected on the basis of report, the application was made with the intention to fraud is creditor, the order shall record the same and shall record that the creditor is entitled to file for bankruptcy order. So, where in a CRP situation where there is a failure for resolution plan, the NCLT will recommend for a liquidation. Similarly, there is a bankruptcy order can be recommended on the rejection of the application. Admission immediately moratorium is set in. Moratorium is section 101. For a CIRP process, moratorium is section 14. Please remember that section 14 and section 101 you will have to read in sync in order to appreciate both the moratoriums in both the places. Is there any change in that? Is there any SWOT? This, that, any changes that we need to have a look at it and we need to come to a conclusion. Consequence of admission, okay, moratorium, where an order admitting the application under 96 has been made to a firm, the moratorium shall apply against all the partners of the firm. So, all the partners who have the heads which are accepted or which are eligible for those things, the moratorium will stand. Again, for certain transactions to be notified by the central government, it is not applicable. Public notice for claim. Now I come public announcement. A public notice has to be made. And the issue is who will make the public notice. Please imagine the DRT fully stuck with papers in the walls. That is how I remembered it. It is the adjudicating authority which must issue the public notice. It is not the resolution professional, as in the case of CIRP, who issues the public notice, the public announcement. It shall be a public notice. Where it is a notice, it is from a statutory authority. Income tax department issues a notice. Sales tax department issues a notice. And the adjudicating authority issues a notice. Whereas the insolvency professional makes a public announcement. Please remember the difference between notice and announcement. Notices are all made by the statutory authorities. He has to make within 7 days. For AA, you have 7 days. Everywhere you see, AA will take more time than allowing time to others. It will refer to the board. Within 10 days, the board has to answer. The AA will take 14 days, but if it is done by a resolution professional, he has to do it in 3 days in case of a CIRP. Like that, you can remember. The AA shall issue public notice within 7 days of passing the order under section 100, inviting claims from all creditors within 21 days. In a CIRP process, I issue the public announcement within 3 days, wait for 21 days for the claims to come similarly to this, and after that I have to constitute a COC meeting within 30 days by giving a 7 days notice period or a 5 days notice period as the case. Please note down the points so that it will be easy for you to compare both the processes and easily remember it. Contents of public notice: it shall have the details of order admission, particulars of RP, last date, and the RP's coordinates, and the notice shall be published in one English, one vernacular newspaper which is circulated. I don't know how AA will be in a position to make all these newspapers and all. The DRT will become a newspaper agency once this thing is notified. Maybe because of these logistic reasons, is that the notification has not yet happened. But just imagine the AA doing all this. It will be a big pain, and there is bound to be delay and other things. In case the RP does the same delay in a CIRP process, making the public announcement on the 4th day, the action is liable to be taken on him. So you need to wait and watch how this actually fans up and how the AAs are geared in this matter to take these matters forward. Okay, now we come to the registration of the claims by the debtors, by the creditors. They will register it by sending the detail by electronic communication or through courier, registered post, or registered letter. There was some instance where it was only electronic. Okay. In addition to creditors shall provide to the RP the personal information and such particulars as may be prescribed in the form. It will form in the regulations. From the regulations, we need to pick it up. Then we have the list of creditors. The RP shall prepare the list of creditors based on the information provided and also the claims received under 102. He shall prepare the list within 30 days from the date of notice. In a CIRP process, he prepares it within 21 days, files it to the adjudicating authority, and convenes the COC. For the purpose of COC, he requires the list to be made, but here the RP prepares the list within 30 days. The debtor shall prepare in consultation with the RP a repayment plan containing a proposal to the creditors for restructuring. The plan may authorize or require the RP to carry on the business. There may be a situation where the RP has to carry on the business like the way he carries on the business in case of a CIRP process. He needs to do that. There may be a situation where he needs to realize the debtors, administer or dispose of any funds of the debtor. The repayment plan shall include the following: justification, provision of fee placed to the RP. Now the bells will be ringing for all of us. Fee to the RP. Fee. Insolvency bankruptcy code is actually a situation wherein the professionals are really honored, and the act itself envisages a situation for the fee to be paid to the respective professionals, RP, in a manner that it is included as the first expense. Even if you see in section 53, the waterfall, the first expense is the fee of the RP. RP shall submit the repayment plan under 105 with its report within 21 days. He prepares it within 30 days. He prepares the list within 30 days. Where is it? He prepares the list within 30 days, and then what happens? He has to do something within 21 days. RP prepares the list within 30 days and shall submit the repayment plan under 105 along with this report of such plan to the AA within a period of 21 days from the last date of claim of this thing. How much ever claims he has, after that he has got 21 days to 3 weeks to make the submission to the adjudicating authority, which is the DRT. The report shall include the repayment plan. The plan with reasonable prospect of being approved and there is necessity of summoning a meeting of creditors. In this, if you had observed, the COC is not being given importance at all in individuals and partnership. It is the resolution professional who actually carries on the whole work, carries on the whole shots. He decides on what to do, etc., etc. So, but in case of a CIRP process, there are enormous amounts of what do you call the COC which is happening. So let us take some questions now. Are these action which we are doing now notified? No. No, madam, it is not yet notified. Form 26AS is an information utility. Sir, Form 26AS is only an information utility, but your ARS form, that is what is that? AR information is much more. In fact, when I was a part of the ICAI Direct Tax Committee, we recommended, I initiated a recommendation to the CBDT asking them to include all the AR information in Form 26AS itself. And it took about 4 years for them to recommend. Now it has been recommended. If you see, now Form 26AS will be akin to your AR information only from the current year, wherein all the purchases, more than 2 lakhs worth of mutual fund, any purchase, sale of property, any transaction, any bank deposit, all those things will come part of 26AS itself. The reason why I recommended such a thing was, I made a point to say that where the government has an information, why don't we share it with the citizen and allow the citizen to comply it and include all of it in his income tax return? Inadvertently, where the person is not including a few things which is available with the income tax officer, immediately interest, penalty, prosecution, all those harassment starts to come. So I recommended it. I'm glad, I'm so very happy that the government has accepted it, and I'm so very happy to Mr. Venkatesan also, because of which I'm able to share this lovely information with this group. Section 101 includes the personal debts of the partners also. Let us see. Let us see. Good question. According to me, it should, sir, because it says all the debts. So where it is initiated against the firm, it is also initiated against the partner. Unless there is a contrary explanation somewhere else, it should happen. So we have completed it. We have completed 106.
Yeah, Ramana sir, there are 4 or 5 more questions. Shall I put it on my screen?
Oh yes, photo blank. I will also have a sip of hot water in between. Yes.
Yeah, sure. Please do, please do. Selva, if you can give me the hosting rights.
I'm shouting from 1 o'clock, so
Question number 12 onwards, sir.
Is LLP covered under CIRP? You tell, madam. LLP is through, I'm not really sure about it. I will clarify it. Before end of the day, I'll ask any of the faculty to clarify it. I'm sorry, I'm not able to answer that question now. If not, debtor apply for PRP. Any creditor can apply. Yes, any creditor can also apply. Yes, sir, you can. Murugavel, even it is notified, you think there will be much professional scope in this area? Because, sir, you first clear the exam, sir. After that, we will enter into some association. Don't worry.
The 15th they have already answered. 16th, sir, actually.
No problem. If different creditors make duplicate on the same partner in different year, how section 95 will apply, sir? for the first application, if it is made in Chennai, that is where I made the example also. In a firm against a partner or against a firm, the first application, say, is made on 1st of May in Chennai. 2nd of May it is made in Hyderabad, 3rd of May is made in Calcutta, etc., etc. All those things will be clubbed to bring it to Chennai, because all the information will be available with the debtor. And during the NCLT hearing, during the DRT hearing, the member is bound to ask this question: is there any other application against you anywhere else? So he has to say, sir, one is in Hyderabad, I have received the papers, one is in Calcutta, I have received, everything will be consolidated here. Similarly, the person in Calcutta will ask. They may know, they may not know. So everything will be clubbed in that place. And divide can be applied. Distinguish fresh start versus insolvency process versus bankruptcy concern. You are writing the exam, I am not writing the exam. You have to study all this. Fresh start is, for fresh start, you know, fresh start, you have to have only 5,000 rupees, less than 5,000 rupees. There must not be a roof over the head, sir. I have been shouting it so much, sir. You must be able to say, Rangasamy sir, you must be able to say the difference now. Insolvency process can happen to partnership firm also. Fresh start is only for individuals. Bankruptcy is the equivalent to liquidation, which we saw in the CIRP process. Okay. If application are made against the same partner of the firm, different DRT by different data, how
I think this you answered.
I have explained it, sir. I have explained it. Who will run the business during the resolution process? If you have been running the business properly, there is no resolution process at all, sir. Invariably, what happens when everything is over and when it is coming to a shutter close situation only, you will come into the process itself. So we need to wait and see on that. So that is a practical question. It is an excellent question. The exact way how it is run in a CIRP, the same way it will be run. Exactly the same. Assuming that you are running a cloth store, the RP must make arrangements to run the cloth store in the same manner. If you are doing money lending business, you have to do. So how will you do that practically? How are we doing as insolvency professionals for CIRP? Allowing the business to be run by the proprietor or by the director or by the people who have been running the business, and you have the bank account with you. You control the bank account. The checks will be made only with your approval. Expenses will be made only with your approval. You should not allow the managing director or the managing partner to buy a Mont Blanc pen. You must not allow him to buy a Mercedes Benz. All those things that control the resolution professional will have. Over that it will come. So no problem.
Yeah, Ramana sir, there is one more question from N. Thirumal. Various timelines given in the courts excludes holidays or not?
Sir, the General Clauses Act will apply for everything, sir. If the 7th day falls on a Sunday, it is on the next day. Monday is assumed to be the last date. So absolutely no problem, sir. It is not an examination question. It is only a theory question or a practice question. You don't have to be worried. Sir, can I show my presentation now, sir?
Selva, if you can give the rights back to sir. Yeah.
So we have seen this. Now the report on the repayment plan. The report on the repayment plan, where the report referred to, shall also specify the date on which the time and the place at which the meeting should be held, if he is of the opinion that a meeting of creditors should be summoned. COC in a CIRP process. COC in a CIRP process is a very important institution to run the company. In fact, the COC actually runs the company. The excellent question asked, who will run the company in a PRP process? Yes, in a CIRP process, the company is run by the COC. The COC will approve or not approve the interim finance. The COC will approve or not approve certain things. And the resolution professional in consonance with the COC runs the business. Here, the creditors will be, if it is required, it is not compulsory, if it is required, the creditor meeting shall happen, and the creditor meeting happen again. Please remember 14 and 28. 14 and 28, not less than 14 days and not more than 28 days from the date of submission of the report. So immediately after the submission, we cannot do this thing. You have to wait for 14 days. You have to give sufficient notice to all the creditors. Between the 14th and the 28th day, we will do it. Right? Okay. The resolution professional shall consider the convenience of the creditor in fixing the date. Obviously, he will have, there is no rigidity. If it is a holiday, you can have it the next day. If it is total lockdown in one place, you keep the meeting in some other place and do something. Meeting of the creditor, RP shall issue a notice to all of them before the RP shall send notice of the meeting to the list of creditors prepared under 104. Under 104, you prepare a list of creditors basis on the information 95 or 94 or the claims received. In that, you have to issue the notice to each one of them as per the thing which you have. So what happens if you receive a notice after you are filing after this 104? Those person will not be accepted as of now. At least for the first meeting, they cannot be allowed in. The notice shall state the address of the AA, all those things will be there, repayment plan. You have to give the copy of the repayment plan, copy of the statement of affairs, copy of proxy and forms for proxy. Again, during the examination, our professional intelligence as chartered accountants will say, why should I give the statement of affairs of the debtor? So, copy of the statement of affairs is not a right option. It will say, copy of the repayment plan only, copy of the repayment plan along with the statement of affairs, copy of the repayment plan along with the balance sheet, copy of the repayment plan along with the financial statements of the debtors. These are the four options you get for this question. And we will invariably pick on the financial statements and we will not pick on the statement of affairs. Because our professional intelligence will come in between and say that, no, you have to do financial statements only. The funds flow, the cash flow, everything has to be given. So we will take that. So please be careful, make a note of it, statement of affairs of the debtors. The way the meeting should be conducted, the meetings may either modify, approve or reject the prepayment plan. Very similar to the concepts which we have in COC, wherein the COC can approve or reject. Here you can modify, the creditors can modify their repayment plan. This is where I'm having a major problem. Do you think any of the creditor will accept the repayment plan given by the debtor as it is? Every creditor will want a higher share of the pie for him. So there will always be modification, and poor resolution professional will have a horrid time on this account. The resolution professional shall ensure that if any modification are suggested to the creditor, consent of the debtor shall be obtained for each of the modification. Please understand, the prepayment plan is prepared by the debtor in consultation with the RP. So such being the case, any amendment, any changes being made, it has to be brought to the notice of the debtor and we need to take the consent of the debtor. If the debtor is willing to pay 1 crore and the creditors recommend repayment of 5 crores, then you have to seek the approval of the debtors, obviously, in order to come to a conclusion. Isn't it not? Which question was there? The RP may for sufficient cause enjoy, okay, for a period every adjournment is only not more than a period of 7 days. In case of a CIRP, if there is an adjournment of the COC meeting, it should happen on the next day, isn't it not? Or as per mutually consented, it must have a on a future date. Otherwise, in all practical purpose, it is on the next day. Every creditor shall be entitled to vote at every meeting of the creditor in respect of repayment plan in accordance to the voting share assigned to him. The resolution professional shall determine the voting share each creditor. A creditor shall not be entitled to vote in respect of a debt of an unliquidated amount. So, what is a striking difference between ARP and PRP? In a CRP situation, only the financial creditors are allowed to vote, whereas in this case, all the creditors, including an operational creditor, is allowed to vote, isn't it not? So please bear that in mind. A creditor shall not be entitled to vote if he is not a creditor in the name of the creditor's list or an associate of a debtor. Obviously, these two situations are very important. Not entitled to vote, a creditor not in the list of creditors. Please remember, as per 104, this list of creditor is being submitted to AA. After 104, if you receive anything, as I said earlier, he cannot enter into the meeting, he cannot vote. If he cannot vote, he cannot enter into the meeting at all. Such being the case, he cannot, he is not entitled to vote in the meeting of creditors. Rights of a secured creditor in relation to repay plan. Okay. The secured creditor is entitled to participate and vote. The secured creditor participating in the vote shall forfeit his right to enforce the security during the plan. There is no harm for the secured creditor to come and vote. He can come, he can participate, he can vote. But once he votes, he cannot enforce his security. The security is assumed to be forfeited and it will be put in the common asset plan, and in accordance to the terms of the asset plan only, he will receive the money. For example, I will give you a classical example wherein the security is lower than the amount to be received. And for all practical purposes, if he forfeits the security, the chances of getting money is more because of the other assets being sold. Such being the case, the creditors will choose to forfeit his right to enforce the security. If it does not want to forfeit the right, he shall submit an affidavit to the resolution professional stating that the right to vote exercise is only in respect of the unsecured part of the debt. Say, for example, the total debt is for 1 crore. The flat which he is having has a valuation of 80 lakhs. So, the extent of 20 lakhs, he becomes an unsecured creditor. He can vote for that unsecured part alone, and the estimated value of the unsecured debt, he has to explain it to them with the valuation or any other means he has. In case a secured creditor participates in the voting of repayment plan by submitting an affidavit as above, the secured and the unsecured part shall be treated separately. So this 1 crore, which as per 104, I have given 1 crore to the AA. That 1 crore will be broken up as 75 lakhs and 25 lakhs, and accordingly the voting will take place, and accordingly liabilities will also change, and the loans or the debts of the debtor will undergo an alteration. Any clarification up till now? Any questions, sir?
Yes, Ramana Kumar sir. One question has come.
Yes.
CA Bhuneshwari, is there differential treatment of financial creditors and operational creditors?
Where
That they are not mentioned.
in the PARP, is there any breakage, any segregation as financial creditors, operational creditors? No, I explained it to you now. There is only one creditor. A creditor shall be entitled to what? Eating of the creditors. The RP shall issue notice calling the meeting of the creditors at least 14 days. He shall send notice to everybody in section 104, the list of creditors, where in 104 are you breaking them into individual creditors and financial creditors and operational creditors? No. The RP shall prepare a list of creditors on the basis of information disclosed in the application filed by the debtors and the claims received by the RP. The claims, are you saying by any chance that the claims only the financial creditors have to give? Even in a CIRP process, everybody gives the claim, no? So for a PRP process, which I explained, as I explained earlier, there is no breakup or there is no differentiation as a financial creditor or a operational creditor. Okay. I think we have seen up to this one, 44, 45. Yeah. The concurrence of the secured creditor shall be obtained if he does not participate in the voting on the resolution plan. Please don't think that I'm just reading from the slides. What is there in the slide is exactly what is there in the section also. So if you can also read it from the section, it will be absolutely right. I have only taken the important salient features of the section and it has been presented. So that is why these are the important things which one needs to know for the examination purpose, and there is no point in trying to exhibit my intelligence and trying to repeat it without seeing the presentation. Actually, it is the section which is there. The concurrence of the secured creditor shall be obtained if he does not participate in the voting plan, but provision of the voting plan affects his right to enforce the security. So there is a situation. The concurrence of the secured creditor shall be obtained if he does not participate, but provision of the prepayment plan affects his rights to enforce the security. Because of the prepayment plan, if there are any situation by which his enforcement of the security is being affected, he can, that has to be taken into account in the repayment plan. The period of repayment plan is the day from which the order is passed, given by resolution, or the order submitted, as the case may be. The period of repayment plan is again an examination question. Period of repayment plan means the period from the date of order passed till the date in which notice was given by the resolution professional or report submitted by the RP, as the case may be. That is the period of the repayment plan or the repayment thing.
Yeah, Ramana sir, a question has come. Secured creditor, whether 2 votes for secured and unsecured portion.
Secured creditors, he is taking away the asset out of the. Okay, let us take the example. Out of the 5 crores, which is my liabilities, 1 crore is to the secured creditor. The secured creditor says the value is 75 lakhs. I will take the 75 lakhs away and the balance 25 lakhs will be there. So while preparing the voting ratio, earlier it was 5 crores, 1 crore is to 5 crores. Now it has reduced to 25 lakhs is to 4.25 lakhs because the 75 is removed from the numerator, the 75 is removed from the denominator. So there is no issue of having 2 votes, and it is not vote by head, it is only vote by value. So the person, unsecured person, will have 25 divided by 125 into 100 is the voting rate which he has, ratio which he has. Understood? The resolution professional shall prepare a report on the meeting of the creditors on repayment plan, whether approved or rejected, whether the resolution proposed, the list of creditors who are there present in the meeting, with proxy, without proxy, who are the proxies, and any other information as the resolution thinks appropriate to be made known to the adjudicating authority. If I was the resolution professional, I will have another column and ask everybody to say that I am not an associate of the debtor. So it will add value to me. Even by mistake, there is one associate who comes in without knowing, trying to defraud in whatever way. I will think any other information should include a column to say that each of the persons say that they are not associate persons and they sign the register or list. He shall provide a copy of the report of the meeting to the debtor, to the creditors, including those who are not present. Again, an examination question. The resolution professional shall provide a copy of the meeting. Again, our professional intelligence will come to say, people who are not there, why should we provide? We will provide only the people who are there at that point in time during the exam. So, he will say debtor, creditors who are present, and adjudicating authority will be one option. Debtor, adjudicating authority, creditors who are present, and IBBI will be another option. Like that, you will have 4 options. You will have to very clearly know that in case of PARP, we have to share the information with everybody, all the creditors. You don't have an option. You have to share everything to them. Even those who are not present have got the authority to receive the minutes of the meeting. Where an authority of the adjudicating authority, the order of the AA may also provide for the direction, how the repayment should be there, who must have priority over whom, all those issues will be there. Upon when repayment record modification, the AA may direct the resolution professional to reconvene a meeting. It is not the case in CIRP process. In CIRP process, you cannot, the AA will not recommend all these things. He will say yes or no, that is all. In this case, the AA might reconvene again, which is a problematic area, which needs to be sorted out. Importance of what is the importance of order of the adjudicating authority? The adjudicating authority shall pass an order to approve or reject the prepayment plan. Accordingly, on the basis of the report, he can only recommend modification, just as any bill which is passed by the Lok Sabha and Rajya Sabha, the president can reject it once. After that, he has to accept it. Similarly, the adjudicating authority can ask for modification to be made, reconvene the creditor meeting, do the modification, and after that, once assuming that the same thing is carried again without modification, the creditor meeting does not approve the modification. On the basis of the report of the meeting, it has to be either accepted or rejected. Where the meeting of the creditors is not summoned, the adjudicating authority shall pass the order based on the report prepared by the resolution professional. So we have seen in section 101, 102 and all, where only if the resolution professional wants a meeting to happen, it will happen. Otherwise, it will not happen. It is within the rights of the resolution professional to do the work without involving any of the creditors also. Effects of the order: where approval for repayment has been granted, such repayment plan shall take effect as if proposed by the debtor in the meeting. Again, an examination question. And shall be binding on all the creditors mentioned in the repayment plan and to the debtor also. So, please understand, it will take effect as though it is proposed by the debtor in the meeting. The repayment plan is proposed by the debtor in the meeting after the grant of the approval by the adjudicating authority, and shall be binding on all the creditors and including the debtor. The debtor, if it is a firm, it includes the firm and the partners also, all the partners also. I thought we would take some questions also. I don't think we have the time to take some questions, but I have addressed a lot of questions during the presentation itself. So let us see if we have time into what are the effects of the order of the adjudicating authority. Adjudicating rejects, immediately the creditors are entitled to file an application of bankruptcy, which is equal to liquidation. In a CRP situation, liquidation is applied, is recommended by the COC, and application is made by the RP, and the RP becomes the liquidator upon acceptance. Whereas here, the creditor shall file an application for bankruptcy. You have to appreciate the subtle difference between the two. A copy of the order has to be given to the board. Obviously, wherever there is an order, the board will come into play and the board has to be given. Wherever there is an order, it has to be given to the board for the purpose of records. Please remember it in that way. Who shall implement and supervise the repayment plan? The resolution professional appointed. Here you see the same resolution professional is not the person who is the who was the resolution plan, who was the resolution professional for the process. That is not the person. Another person may be appointed. What do you call the resolution professional appointed shall supervise the implementation of the plan. That resolution appointment may apply to the adjudicating for any directions like in section 60 within brackets 5 in a CRP process. We can apply to NCLT similarly for any directions, no cooperation, no repayment, that are not picking up the phone. All those issues can be raised by him. The adjudicating authority shall direct the direction accordingly on the basis of the application. When does the repayment plan complete? Extremely important and a very vital question. Please study it at least very well. The resolution professional shall within 14 days of the completion of the repayment plan forward to the persons who are bound by the repayment plan and the AA the following documents. First is a notice that the repayment plan has been fully implemented. You have to share this to the creditors also. A notice that the repayment plan has been fully implemented has to be shared with the creditors also. Again, our professional intelligence will say when we are reading the question in the examination, it is because of the creditors only we have completed the plan. Why should we inform them? Is one question which will raise, but please understand, as per 117, you will have to share the completion of the implementation to the creditors also. And a copy of the report by RP summarizing all receipts and payments in pursuant of the plan and the extent of implementation of such plan has to be shared with everybody. And he shall also apply to the AA for an extension of time, and the extension of time will be within 7 days, not more than 7 days. So there is a time limit given by the AA or during the repayment plan by the debtor. And fortunately, he is able to complete it prematurely, beforehand itself. A repayment plan shall be deemed to have come to an end prematurely if it is not implemented. Even if it is implemented, it is assumed to be implemented in a way that where the prepayment plan is completed, even though if it is before the date, the maximum date which the AA gives, it is there. Where the repayment plan is unable to be fully implemented in all respects, it is a premature closure. In that case, again the receipts and payments, the reason and the details of creditors who have not been fully satisfied has to be shared with the adjudicating authority for taking it forward. Due to various reasons, while repayment, a few creditors would have been left out and it can be taken there. Adjudicating authority shall pass an order on the basis of the report that the repayment has not been fully completed. The debtor or the creditor whose claim on the repayment is not fully is entitled to apply for a bankruptcy order. Only the person who is not fully satisfied is entitled to a bankruptcy order, or the debtor himself can apply. I'm not able to repay it fully. It's a very sorry state actually. He has been trying to do it. 85% I have completed, 15% I'm not able to complete. So I will enter into a into a bankruptcy situation. He can also apply, or the creditor who is not fully satisfied. Not being fully satisfied is important here. Again, an examination question, a conceptual question. It will say not satisfied, not fully satisfied. Even though he's satisfied little bit, he cannot make an application. Such questions will come in the examination. Now, last, what happens after all the process is over? There is a discharge order. The resolution professional has to apply to the adjudicating authority discharge order in relation to the debts mentioned. Only to the extent of the debt mentioned in the repayment plan, you have discharge order. For all other debts, it is not there. Please understand that. And the adjudicating may pass an order. The repayment plan shall provide for an early discharge on the completion of the repayment plan. Anything will happen if, in case there is an early discharge, which is there as part of the repayment plan, early discharge also will happen. Again, it will be forwarded to the board. The discharge order shall not discharge any other person. If the partners, for all the partners, it is applicable. If it is there for any other person other than the liability of the debt, it is not applicable, for which a fresh application or a new application shall be done. The RP shall perform his duty according to the standard of conduct. Section 120, if you see, I have not made 120 here. The resolution professional shall perform his function and duties in compliance with Section 208 in accordance to the Section 208 of the standard. So he has to do it. This is Section 120. Okay. So, which is not applicable to you is the status of the commencement of the Part 3. Only in 15/11/19 has the central government made the issue on the guarantors to corporate debtor. It is not applicable to you for your examination, but as a matter of abundant caution, you can just go through this. Section 2E, Section 78, 79, and Section 94 to 187 are applicable in this manner for the corporate debtor, the guarantors of the corporate debtor. And when you read it in a holistic manner, it will also come into play. And one more thing is, with respect to the guarantors of a corporate debtor, the adjudicating authority is NCLT. It is not DRT. Please understand, in the case of a situation where, again I am repeating, for a guarantor of a corporate debtor, even though he is an individual, the adjudicating authority is NCLT. It is not DRT. Please understand that. So, any questions, sir? I think I have completed within the time you have allotted to me, Chairman, sir. So, if there are any questions, we will take it up. Hello. People can ask in the chat box also. estimated value to be, what is this English term? Whether the onus of providing such a creditor is an associate not lies with the RP. RP also has to be, sir, you are like RP is like a situation where he can be blamed for anything and everything. He will be like the Modi. Everything bad happening is only because of Modi, everything good happening because of Modi. One party will say like that, one party will say like this. So for everything, the RP will find himself in between. So the creditor is an associate or not, as for practical reasons, one need to take some action to see how he will be safeguarded. He has to take action as how he will be safeguarded. Dugarjanji?
Yes, Ramana Kumar,
Yes,
sir.
sir.
There is one question from CA Gautam Chandian. Can RP invite debtor in the meeting of creditors?
Debtor will be there. Yes, it is he who is preparing the application. He will just keep quiet. He will be an observer. If you see the CIRP process, in the CIRP process, the debtor is invited to every meeting of the COC. Debtor does not have voting rights. He cannot speak. He has to be observer. Similarly, a debtor can be made to sit in the meeting if he wants. If he wants, the creditor meeting itself is an option only in a PIRP. Such being the case, if he wants the debtor, if he wants the meeting to happen, it can happen. If he wants the debtor to be there, he can come. There is some question on 116 implementation and supervision. Oh yeah. This appointment will be made by AA invariably. 99% of the time, this appointment will be made by the adjudicating authority.
Can you communicate to AA electronically?
Sorry?
Can you communicate to AA electronically?
If you go there and ask them itself, you won't get an answer. If you try electronically, we will see. No, I don't think so, sir. It is not practical. All these questions are, theoretical questions. Adjudicating authority, invariably it is advised to go there physically and only check. Only in the period of COVID, DRT is not functioning at all now. It has been closed after a series of positives there. Example, by NCLT we are able to do it electronically. We are able to send the material, but a huge amount of follow-up is required, sir. Huge amount of follow-up.
What is the hierarchy of authority in IBC code?
What do you mean by the authority of hierarchy? Who has asked it? If you can unmute them and ask them to ask. Is it possible, sir?
No, question is asked by Pandurang Simpi.
I will show you one presentation which I made to Ernakulam some time back. 1 second. Hierarchy, I have one. Hierarchy. I will see if I have it here. Introduction, I must be having the hierarchy. I will show you the hierarchy. If you see, sir, if you see actually the hierarchy in the code is the professionals are in the base of the pyramid. Above that, you have the agency. Agency is a Section 8 company, which you will read on 30th. The agency is a Section 8 company. There are 3 agencies as of now. One is by the CA Institute, the other is by the ACS Institute, and the third one is the Cost Accountants Institute. All these 3 institutes have got agency. All the professionals will be embedded with the agency. They will be registered with the agency. And even now, the classes which you are attending under the institute classes. These classes, after you pass the examination, you will be made a member of this agency, of the institute agency. Then after that, you have the board. The board is nothing but the IBBI, Insolvency and Bankruptcy Board of India, based in New Delhi. And it is the act which is administrating the whole board agency and the professionals. Again, we saw what the utility is and we saw the adjudicating authority. This is the mechanism of the code which we have. What else should I tell you? I don't know. Have I answered your question, sir?
Fine, sir. If there is anything, maybe they can ask going forward.
Yeah.
Sir, that last screen, let it be there. People want to note down your contact numbers and details.
Sure. I have shared. Mr. Pandurang has replied, yes, sir. Thank you, sir. Okay. Sir, I have shared the presentation with the institute, sir. The presentation in the form of the PDF can be shared with the participants.
Sir, it is already done. It is already
Excellent.
done. Link has been put in the chat box.
Excellent.
The materials are available for download right away. The last
Excellent.
page actually contains the link, details of the speaker.
Okay, yes.
So I think we have taken all the questions then and there. So any further questions, maybe you can ask the next speaker who will kind of take care, or you can always reach out to our Ramana Kumar sir through the email or the mobile number.
Yeah. Before closing, I would just like to give some tips, practical tips on
Yes, sir. Please do,
the
sir.
passing
Please
of
do.
the examination. Okay. Sir, the examination is a very simple examination if you have fully prepared for it. It is like a CA final examination, which I explained earlier. But be as it may, I'm not trying to frighten anybody. All of us are chartered accountants here. All of us are professionals in some form or the other. We will be able to crack the exams very easily. All you need to do is to prepare systematically. What invariably happens, what my students have given the feedback is that, sir, in examination hall, I'm unable to remember what is what. 14 days or 28 days or 21 days, I am unable to remember. Remembering, it is only a test of memory. This examination, the limited insolvency examination is only a test of memory. If you have a strong memory, you pass. If you have a weak memory, you have to write again. That is the only difference. So you will have to structure something. Case laws are most of the case laws which you have in the syllabus are only asked. There will be twists and turns in the case law. I think tomorrow you have the case laws. Please make an effort to download all the case laws you have. Take a printout if possible, and as the speaker is speaking tomorrow on the case laws, you can make the finer points. And coming back to the limited solvency exam, you need to make a number of charts. First chart is the process. Second chart would be the days, 14 days, 10 days, 28 days, all those things you'll have to make charts. And these charts have to be made by you only. Please don't copy a ready-made chart. I can circulate my charts to you, but that is of no use. You will have to prepare it yourself. I would recommend each one of you to prepare it yourself. Third and the most important thing, please don't write the mock tests and compare the results with the final. I might be creating a controversy here, but I am just sharing what I have done for the simple reason that the more mock test you do and you write it and just check all the answers afterwards, you will feel dejected or you will feel elated, both of which is not true. You need to read those questions, you need to read those answers, you need to know what is right and what is wrong, and also check how the questions are being manipulated. Or how, like for example, I explained that 94, 119 and 138, all those things, 92, all those things which I explained, all those confusions will come. So you need to write and only check. Do you have MCQs? I have a lot of MCQs, sir, but MCQs of no use as of now. Please first read the Act and regulations. Make notes. Form A for what? CIRP Form A is different. Bankruptcy Form A is different. Liquidation Form A, B, C, D are different. So you need to make a chart. Everything has to get into the head first of all. And the regulations also will be asked. Form A, B, C, D also will be asked. Even if you get 4 marks in that, that 4 marks will be a make or do or die situation, because either you get 4 marks or you would lose 1 mark. So the bandwidth is 5 marks, isn't it? And because of the negative marking, you have to be doubly sure before you click an answer. So you need to do that. Number 3, there are some case laws which will come. In the examination, the case law first, if you click it, it will come in the full screen. Later on, what will happen is, for the second time when you see it, it will be so small that you have to strain yourself, you have to strain your glasses. So you are allowed to take 1 sheet of paper inside, empty blank paper inside. So what I would recommend you is, as soon as you see the case study coming up, write the case study down, the important features of the case study, write it down, the numbers, 4 crores or 44 crores, you can see only when the numbers are big. When the numbers are small, you won't know the difference between 44 crores and 41 crores. And please remember, the answer will have 1 for 41 crores also. So you will think that 44 crores is 41 crores, you will make the answer, you will find the answer right there, you will just click it. But the answer is wrong. Please understand that. So please make short notes on that, the important salient features in that plain sheet of paper, and answer the questions accordingly. There will be some situations wherein, as a strategy, you will have to omit those questions. Case law citations will come, and the name of the case law will come along with the issue in that. If there is an issue like that, if you know 100% click, otherwise it is a ball outside the off stick, please lift your bat, let it go to the wicket keeper. You will not lose that quarter mark. Friends, please remember, I know of my close friends not able to pass by getting 59.75. 4 times it has happened. There are individuals who have got 59.5 and they have failed. I'm sorry, it is half mark. I'm sorry, it is half mark. I have got people who have got 59.5 and failed. So what I'm requesting you is, kindly don't attempt any question which you don't know. Please understand, if you attempt 4 wrong questions, 2 marks are out, isn't it now? So kindly be very careful about it. Only for this reason, you need to prepare it like a child. You have to prepare like a +2 examination. You will have to make all the charts and prepare. And one more suggestion which I have is, it might be again controversial, but this is how I have done. There is an option for you to come back and make the answer. I would strongly recommend you not to do that. If you know the answer, you know, otherwise you don't know. Simple, period. There is no point in reviewing. Please don't try to review anything. You will have a problem. And the last important thing is, as you are answering, because you are not writing, you are only clicking the answers. As you are answering, you will find that in 15 minutes you have completed 50 questions. Please don't get bogged down. In 15 minutes I have completed 50 questions. No, you are on the right track. Please continue with the same flow. If you try to reduce the flow, read the question again and again, you will get confused. Because again, I'm telling you, it is a test of memory. Nothing more, nothing less. So I think we are at 8 o'clock. I wish you all the best. I pray Lord Almighty that you complete all your exams in the first attempt and I wish you all the best. You have any clarification of any sort, I am a phone call away. You can drop me, you can drop an email. I will try to answer it as much as possible, as early as possible. I will try to answer it. And last but not the least, please buy yourself a Bear Act from any bookstore. You need the Bear Act, and with the Bear Act, you need some pencils and also some highlighter. This actually, the Bear Act should become like a waste paper. The more you study, for people who know Tamil. So, with this, I place on record my very sincere appreciation to the SIRC of ICAI for having accorded me this lovely opportunity to interact with you on the topic of the part 3, which is the insolvency process for individuals and partnership. And I place my very sincere thanks and special thanks to the chairman, who has been, kind enough to be present personally in this program. And I hope and pray that all of us are safe, and we jointly cross this situation, and all of us come back to normal, and hope to meet you all very soon in the SIRC as a party for clearing the examination. Thanks a lot. If there is anything else you have to say,
no,
sir.
Ramana Kumar, all questions we have answered. Thank you so much. In fact, there's a nice suggestion that you must buy a Bear Act, and it must be barely readable with all the markings here.
Barely readable, yes.
So to borrow the vote of thanks, I would like to quote what Pandurang Simpi has said: excellent speaker, nice presentation, knowledge enrichment, and beautifully enlightened. So these are the words which have come from the audience themselves, rather than me telling the thank you. Thank you so much, Ramana Kumarji. As usual, outstanding. And you have given full justice to the 4 of us, and our members stand to benefit. And let's hope that all the 100 people who are attending go on to clear the exams actually.
Sir, one second. Somebody is asking 118 subsection 4. One second. 118 subsection 4. Somebody is asking a clarification. I'm so sorry, because the institute is my mother body, so I can take the liberty of being informal. So please don't mind it. Somebody say the debtor or the creditor whose claim under repayment plan has not been fully satisfied is entitled to apply for a bankruptcy order under Chapter 4. Yes. See, where under a repayment plan, let us take the example of that 1,75 lakhs and 25 lakhs. Out of the 25 lakhs, I have been repaid only 15 lakhs. So there is a balance 10 lakhs for which I am not satisfied creditor. So for that balance 10 lakhs, I can initiate a process of bankruptcy against the debtor and initiate the whole process. And so he will again, it is equal to a liquidation. Where I am not fully satisfied, I can make an application for the bankruptcy. I hope I am clear on that. I don't know who made it. Okay, somebody made it. Okay. That's all, sir. Thank you, sir.
Thanks once again for taking that extra question to cover everything.
My pleasure.
Thank you so much.
My pleasure.
Thank you all. And as he said, stay home, stay safe, and be careful at all times. Don't venture outside. Things are not good at all places. So stay careful, all of you. Thank you. Take care. Ramana Kumar, sir.
Thank you, sir. All the best to you. Be safe.
Right, sir.